Yes, madam. 1 minute. 1 minute. This SHRC thing order we have interpreted section 12. Section 12 SHRC we have interpreted and have sent print out. Yes. Yes.
Page 4, item 12, 27.
Yes.
Page 3, item 28, 41. Page 4, item 40, 54. Page 5, item 64.
No one. Are you? No mention. Yes. Yes. Lunch motion. What urgency? House being demolished.
Medical diagnostics.
You are not being treated as a resident of Telangana. All right. So, can we take it up tomorrow? Oh, not tomorrow. Correctly. You should say 15th August. It can't be taken tomorrow. All right, today.
Action candidate. The repetition of
Admission. Admission.
it is for hearing.
For final hearing, please move an application for early hearing. We will fix the date. We are telling everyone. Yes, madam.
Your Lordship, kindly leave, my lord.
Medical admission.
No,
Your medical admission.
my lordship.
Then, what say?
If your lordship recollects, this is with respect to
yes,
the
so what
transgender
happened?
matter. The first round of counseling is completed
Ah.
and all government seats have been allocated already. And the petitioner hasn't gotten any special reservation in that category.
We don't know.
We've-
Day after. It has
Right.
already been done. Day after. Yes.
Your lordship, kindly leave, my lord. This matter is relating to MCC, my lord.
No,
That
final hearing you want, madam. What do you want?
I filed an application, my lord.
Early hearing.
Yes, my lordships, because the selection is.
Yes, you are in medical. Where you are filed application for early hearing day after.
I
Day after.
filed an application, my lordships.
Early
already.
hearing, no?
Yes, my lord.
Day after. That application will come up. Early
Yes.
hearing, then we decide a date. Yes.
The matter pertaining to temple land of 11 acres given for acquisition illegally, my lord.
No, you are temple. It your land.
Obtaining this litigation, my lord.
That's.
My lord, pleadings are over, my lord.
The final hearing, just madam did. She filed an application for early hearing. Follow. Yes.
Subject to your lordships, kindly, my lord. This is a matter pertaining to
Which matter?
challenge to rules, my lord. Your lordships, this matter came up on second. Your lordships are pleased to defer the matter till the outcome of the Honorable Supreme Court order. Supreme Court, Honorable Supreme Court has passed the order dismissing the SLP, confirming the order, my lord. Writ petition has to be allowed. On 11th August, the Honorable Supreme Court has passed the order, my lord. Your lordships may.
Which you did not tell
I'm
us
sorry.
which rule.
My lord,
There
this
are
is a
so
rule.
many rules in Telangana. Which
See, I'm sincerely sorry. This is a rule pertaining to, my lord, allowing the B.Ed candidates to take paper 1 in tech.
Then urgent hearing, file, bring it on record, SLP, right? Along with an application for disposal of the case, say that in view of SLP, will supply the copy to the other side. We will list it tomorrow, then he will seek adjournment.
Very well. I'm grateful.
And if after filing memo, if you feel like you can mention, we will give a date. If it's not being listed, we are being told that fresh matter comes up next day. Yes.
Great.
Lordships kind indulgence.
Be it, yes.
Lordships kind indulgence, my lord. Vacate stay
Yes.
petitions in writ appeal matters, my lord.
Ah.
Where writ petitions pertaining to year 2003 matters, my lord.
We should fix it for final hearing itself. We didn't know that 2003 intra-court appeal is pending.
Writ appeal arises in 2003, my lords, where writ petition was disposed of in
You want
2022,
vacation
my
of-
lord.
Your consideration of application for vacating stay. 18. These figures are correct, madam. Updated figures.
These are updated, any surprises? Why?
Right. Saturday.
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 My lord,
Saturday is a working Saturday, right? That means you will have to come to the court.
your lordship, for withdrawal.
Today, just now. Yes. Lunch motion for withdrawal.
Yeah,
Today, granted. No, today.
okay. Let's do.
Why? To
Withdraw,
keep
they
it
want
pending.
withdraw.
Withdraw immediately. One counsel mentioned and told us that against a measure under 13(4), I have filed a writ petition. We said instant justice. Mentioning memo taken. We said list today and order passed. We told him certified copy. Today he got the copy.
Okay.
That's so, right? Withdrawal is in that category.
My lord.
Anytime. Yes. Yes, madam. Yes.
My lord, in my third eviction suit,
Huh?
the trial court passed eviction, presumption eviction order without hearing my evidence on both and no notice for hearing. So that I appealed in second appeal, 638.
No, Mr. Francis,
For
what?
remanding back is
Mr. Francis, what is the matter? What is the matter relating to which subject, Francis?
I have sent an email grievance petition to the Chief Justice of Supreme Court for remanding back to the trial court.
Then you have already written to Chief
Mr.
Justice of
Francis,
India. What can we
Meet
do?
the registered judicial.
That will for remanding back to the.
Tell him second appeal roster is not with us.
That's why I'm telling him, Francis, to meet you.
Tell.
This is a email grievance petition treating as a
Mr.
supermarket.
Second appeal, we don't hear. Second appeal, find out which judge hears and go there. Yes.
Mr. Madhu and Vijay Madhu.
Met the revision may not file by the plaintiff petitioner, Lord, filed against an order, Lord, dismissing an application for Order 1 Rule 10.
Learned senior counsel for the petitioner submits that the commercial court ought to have appreciated that respondent number 1 and 3 are brothers and are operating the firms from the same address. It is further submitted that the implement of
They are pressing
It's
for
your
the
suit.
trial, my lord.
2017 suit, you want stay, fine.
My lord, 70, they are pressing
No,
for the
whatever, heard on.
trial.
We thought that your suit you would not like, but fine,
But,
heard on the so and so. In the meanwhile, further proceedings in OS number so and so shall remain state.
Oblige.
Heard on IA 1 of 23. Meanwhile, date, he is not in a hurry, his suit. He is not in a hurry. He wants stay of the suit. Why should we hurry? Yes,
My
don't know
lord, you
date.
can fix some date, my lord. In fact, there is a connected revision, my lord, where the
No,
council
we
claim
thought
was
that
allowed.
you are not in a hurry. You want to wait.
It's not that we want to delay it, my lord, but they want pressing for the trial. Therefore, I wanted a stress. And the CRP, my lord, can be posted along with number. Sure.
12/9/23.
The writ appeal is filed against a common order of the learned single judge. Before I proceed, there is a connected matter which is posted day after tomorrow. Writ
List
appeal
along with WA
776 of 2023.
23 on
It is posted on day after tomorrow, 16th,
what is
16th of
16th
August.
August.
My lords, my lords, I beg to represent R. Vinod Reddy. My lords, I request this court to take up this matter next week,
Why?
as my senior has undergone with a minor surgery, my lords.
Madam, read it.
Sorry, my lords. With a minor surgery, my lords, my senior has undergone.
Delay we will condone.
Delay of 31 days, my lords.
Heard on IA so and so 1 of 23 same matter for reasons assigned this all pro forma delay of before that we hope
Yes, my lords.
21st. Then Saturday, working Saturday.
Yes, my lords.
There is a judgment against you, madam. You should study it, right?
Yes, my lords.
We have told you, recorded in the order sheet. We hope that you have, what is the citation?
Yes, my lords. Recent
Citation.
judgment. KC Nenan versus Kerala State SEB,
Ah,
2023.
read it and come next day.
Yes, my lords.
List on Saturday was what? 19.
My lords, may I request it in a motion list, my lords? Motion list, in a motion list.
It is not as admitted as yet, madam. It will obviously come in motion list.
Much
We have not admitted your petition. Only delay has been condoned. Appeal.
obliged.
What happened to this thing, Mr. SLP?
The SLP numbered, my lord.
Numbered. Same status.
If the lordship permits,
civil.
say
Note-
one thing.
Was the notice ordered,
The
Mr.
other
Kapoor? Notice ordered?
No, man.
No,
It was numbered on.
same order. These,
One.
in this writ petition, comma, the petitioners who are contract
176.
employees employed in
Kindly pass your mind. I am for the response. Senior will appear in this, my lord. Kindly pass it.
Also,
Pass it.
Item 7D.
Come with me. Yes. Which case, ma'am? 7.
My lords, I'm the petitioner in person. My advocate on record, he is an heart patient. And then he has undergone open heart surgery sometime back.
Who, you?
Not me, my advocate on record, I'm the petitioner in person.
Then
Yes,
you want to address us, right?
So I would like to actually handle this case as party in person. I'd like to handle this case as party in person.
You have obtained the leave from the committee?
Yes,
Party
because
person committee?
I will go before appear before the
Please
committee.
go. 14% prays for adjournment in order to enable him to produce a certificate from 14% committee. When do you want?
Monday. Because the matter is on.
Possible. Saturday you can come. This Saturday we are working.
Okay. But I'm not sure if they are going to hold the meeting for that time because on Wednesdays and Friday, Saturdays they hold it.
No, you approach them. You can't appear without a certificate. This exercise.
I'll appear. I'll appear.
No. What we are telling is you cannot appear before us without a certificate. That's the rule.
In this case, it has to be referred to them, so I'll do it. Unless the matter is not referred there, they won't call me. That is the point. So if.
Mr. Whatever it is.
Yes, Lordship.
You can't address this court without seeking permission of the committee.
Yes, Lordship.
You do it whatever it takes to do.
What is required is, Lordship.
since the petitioner intends to appear as party in person, the matter is referred
To party in person committee.
for appearance of the party in person before the committee.
On
Which
which day?
starts.
Tomorrow?
Huh?
Tomorrow, you say tomorrow.
He shall appear before the committee for getting certificate.
You appear tomorrow before the committee, there is a direction. And list on whatever, 19/8, Saturday. Yes.
Item 6 and 8 go together, but in fact, Lordship, I could not present. I am extremely sorry, my lord. 6th matter was kept crossover. These two contempt appeals are agreed by the orders for the learned single judge.
No. What do you want?
Within 1
You want
month.
to argue?
No. Within 1 month, I am prepared to pay the entire amount. I will pay, my lord. Today, my lord,
No, if you are paying, you are ready to pay, that means no further enhancement. But this does not wipe out your past conduct of
Giving an undertaking, doing an undertaking in 2019 and breaching that undertaking.
But they have
There is no
vacated.
justification.
No, they have vacated the premises. They are prepared to pay within 1 month, but finally, otherwise they will go to jail, my lord. In fact, I will inform them, my lord. 1 month time may be granted.
No, we will not grant any time. We will adjourn it. You report compliance, then only we will hear your
Yes, my lord.
contempt.
Yes, my lord. I will report complaints, my lord. Last may kindly grant 3 weeks, my lord. Your lordship so pleases, my lord. They are scrap.
That doesn't mean, Mr. 3 weeks, granting of 3 weeks time, posting it doesn't mean that this sentence has been reduced. We will hear you. Why you did not do it till now? Waiting for the permission of the division bench.
No, it's not that, my lord. It's not that.
What is this? Who is he? I think above law, your client.
No, one is a scrap, my lord. Two people are the, my lord, the tenants of the house. One is a.
Is this person above law? Who is he?
He was doing scrap business, my lord. But in fact, he has vacated.
Everybody, including us, are.
Everyone is bound by law, my lord. I do it. I have no say in the matter. my lord.
Don't argue.
I am requesting your lordship, my lord, for
No,
complaint.
we will decide when to send you. First, you comply.
But 3 weeks, my lord, your lordship.
Ask him to be here next date. Perhaps from here he may be sent.
I'll pay the money, my lord, your lordship. So the poor people, my lord, I'll deploy them.
Mr. Don't dilute the authority of the court. You are an officer of the court for a sake. Don't dilute. Let the law take its own course. His conduct is unpardonable. He has not complied with. You should have said that I will file an appeal only when you report compliance as an officer of the court. You are seeking time. Why should we give time? You argue what is wrong with you.
I cannot.
No.
There is no merit in my case. I do agree. I only say, my lord,
Dismissed.
your lordship.
We will not recording your concession,
For
but we will
complaint.
dismiss it. Why to adjourn?
3
Nothing.
weeks for complaints, my lord, your lordship. I will ask my client to pay the amount.
No, don't. It will be compliant. Just why do you get in between? This appeal. Fine.
So, please, finally.
Anything else on merits, Mr. Anything else? On merits, please. No, all.
3 weeks, my lord, your lordship, so please, just, my lord, finally, my lord.
No, no, no. What?
10 days, my lord. 10 days I'll pay, I'll ask them to
You
pay.
can,
I'm extremely sorry, my lord.
you
I'm
are
asking-
competent enough to advise him what to
No,
do.
nothing, but
Huh?
10 days, my lord.
File another suit
So
and
please, just,
saying
my lord.
that the order passed by learned single judge does not bind me. Do whatever.
So please, just, my lord, 10
No,
days, my lord,
nothing.
10 days time, my
No,
lord.
no, we are not.
Finally, my lord.
Mister, we are not pleased in the matter of violation of orders.
Lakshmi,
This
kindly
would not
consider,
be-
my lord. Kindly consider, my lord.
What, Mister, this is not mercy appeal. It is an appeal under section 19 of the contempt
I
of
agree,
court
my lord, I
act.
agree.
What? This thing, 10 days. Why you did not tell him to comply?
In fact, I have asked them, they are ready, they are ready.
Let him suffer, no?
They are ready with half of the money, my lord. In fact,
We
they,
don't know. Half, quarter, full, we don't know. We are
it
not.
is only
concerned.
2.5 lakhs within 1 week, my lord, your lordship. So last day, last request, my lord, 1 week. Lordship, so please,
You
just.
know, we are not sitting here.
But I also requested my other side counsel.
Other side, you should go before learned single judge, seek modification that I want extension of time. If she does it, fine. We cannot, this is, appeal is not a means to say that now I will comply and therefore no contempt is made out. This is not the argument. We will not entertain. You withdraw with the liberty to file an application seeking extension before learned single judge, that is understand. But we will not interfere in
I may
this.
permit to withdraw.
This appeal under section 19 of Contempt of Courts Act has been filed against an order dated 25th April 2023, by which the appellant has been found guilty of violating
Item 9.
Obliged.
Please, Lord. Lordship had given me Lord time on the last date.
Yeah.
1 week to file counter, my Lord.
so
Well, we have filed it today. We have
Today.
served a copy. And Lord, I have a copy here for your Lordship here. The other aspect.
you would like to go through the reply?
My lords, I have seen the counter, not much there.
Huh?
Not much there, my lords. I have gone through the counter.
Let it come.
Yes.
Let it come before us.
Yes,
And
yes.
19th August, Learned Counsel for Respondent submits that he has filed a counter today. However, same is not on record. Office is directed to trace the same and place it on record. List on 19/8/23.
Please may make a submission.
What happened before the trial court?
That's what I was going to say. The matter is listed today for hearing on 39(1) and 2. They filed their counter on Wednesday. We were given time to file our rejoinder.
So counsel,
We
if
are
you say
filing-
so, we can, that very day
We
also.
can go
we
and
can
argue there.
decide.
No, my lords. May I make a submission?
We will decide 19th August. You have told us that you will argue for 1 hour. So this kind of a situation is.
Now I am willing to argue, my lords,
No, no.
maybe not for 1 hour.
No.
Lesser than that.
No, please, you will appreciate that keeping everybody present, waiting and hearing an argument on 39.3 for 1 hour. We don't think that this should be permitted.
The other day I
It is for
pointed out,
admission, we will admit the appeal. What is that?
no, no.
We will hear you at length.
The difficulty, my lords, is this, that my stock is stopped now.
Fine.
And in the lower court, they have taken time to file a rejoinder. Even before I stated I'll file a counter, they came out with an offer of rejoinder. My lords,
Mr. Senior Counsel, we have fixed your case on 19th of August. Counter is not on record. Instead of arguing for 1 hour, prepare a synopsis and conclude your submission within 5 minutes. That is understandable. Otherwise, if you threaten us with 1 hour, it will come in usual course. No hurry, you can approach Supreme Court against our order.
no, no.
This is except for the monetary stake, there is nothing. It's a simple order. As an advocate, if you have practiced on district court, you must have argued so many cases of 39.3. Hundreds of cases. There is no appeal against an ex parte order granting injunction. That is the scope. You say, I will argue 1 hour.
No.
So then it will be heard. That's why we have kept it on a Saturday. We will hear you at length. No point in keeping in the speed.
39. My point is also on section 12A of the Commercial Courts Act.
You can
I will not, I will not,
12A, you can raise an objection where the matter is pending. This is not the scope of the appeal where you are. It is one of your contentions that since 12A has not been complied with, therefore the order, ex parte order of injunction should be set aside. That's a
I am only on a prima facie case.
Sir, we have noted down everything, but you think that we are slow in grasping and we will not understand. What can we do?
No, 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 my lord.
Please give judges who are 15 years this side.
I first apologize, my lords. That is the message I have sent across. This is not so.
That is to argue in a petition appeal against an order under 39.3 for 1 hour. It defies logic.
My lords, I'll complete it in 5 to 10 minutes.
That's Saturday, 19th August.
Please, Judge.
And give a synopsis and conclude within 5 minutes. Then only we will take up. You can't be like, oh, hold the court ransom. Because you are a pharmaceutical company. Pharmaceutical company is as much a litigant as anybody else present here.
No, my lords.
Teacher, government school teacher is also entitled to same parity.
My lord, the difficulty is public health is involved. That is only my concern.
This order is also, you have your remedies. 2 orders we have passed. 1 hour, 50 minutes from here. Most welcome.
I will not have up to this court if the lower court had taken its own time to pass.
We have passed an order. That we have said that he has filed counter today, which is not on record. We have directed the registry to place it on record and fixed your case on 19.8.
I'll submit a synopsis also. Please.
Oh, yes. Appeal has already been admitted.
I appear for appellate, my lord, in this matter.
Modification what?
You filed IA.
Yes, my lord, I filed.
You filed
Releasing the balance.
We
fund.
did not find which order you are seeking modification. At least yesterday when I went through, I didn't get it. Which order, Mr.
My lord, that is the modification, my lord, petition page number 21, your lordship's receive, my lord.
21? Order, it has to be there in the order sheet, right?
In IA number 1.
Which order?
My lord,
Order
page
dated
21 in IA number 21, my lord.
No.
Order dated
You are seeking
2022.
modification of order passed. Mr. First of all, we have to begin. You should know your case. That
Yes.
the modification you are seeking of which order
Yes,
passed in this commercial appeal or trial court, whatever commercial
in
court.
this commercial appeal.
Then we asked you which is
Yes.
the order. You didn't tell us.
9th day of March 2022,
Nine.
my lord, at page 21, passed in this commercial appeal in IA number 2 of 2022.
Yes, 9th. So,
IA number 2 of 2022.
so you don't want breathing time.
No, my lord, I am the decree holder.
Ah.
My lord, the amount,
Modification.
but I have a decree.
He has
my lord,
deposited the amount.
50% he has deposited, my lord, not 100%.
Then
What that has been withdrawn, my lord, the solvent security was required to be given. But usually when this honorable court, my lord, is passing orders, my lord, of 50% without security is being allowed. But at that point of time, 50%, my lord, with security was allowed, and bank guarantee is costing me 1 crore per year.
So that is why he is not asking the balance and the also to be paid. So
Then usually,
this grievance says that this 50% amount you should be allowed to withdraw.
but I've withdrawn, at that time condition was solvent security, for which a bank guarantee was required to be given, but which is costing me approximately 1
You
crore.
file this thing, undertaking before the commercial court, that in the event of he succeeding in the appeal, you will like
I will
undertake.
withdraw the money. That may be modified to that extent. Order may be modified to that.
Yes, yes, mark the presence.
But I can even give a corporate guarantee if you want. Not
Corporate
just the
guarantee.
undertaking.
Fine, corporate guarantees
Or
also. fine.
undertaking or a corporate guarantee.
He is not at
Last time what happened, my lord?
He is not at
I've
flight,
given undertaking, my lord.
he is not at flight risk.
Yes.
No. One of the partners, my lord, has been declared insolvent. Liquidation proceedings are pending. For that reason, solvent security.
Corporate security will furnish, yes.
And
This appeal under section 13 within bracket 1A of the commercial.
Lord, in this matter, my lord, I appear for the respondent, number 1, who was a writ petitioner. Lord, today we filed a counter, my lord, maybe it has not reached your lordships. There is a delay also, my lord, 245 days.
What, condone how much delay?
245 days.
What do you say? No moral right to.
appearing through
Huh?
merit.
Who?
Item Ravichandra sir is appearing on.
Ah, yes, Mr. Ravi.
This is item 11, my lords. I'm sorry.
11. Condonation delay, we are sure you won't oppose.
No, I appear for respondent.
I'm the
I filed a counter for his delay.
Oh, you want to,
I filed a counter, my lord, but it's not reached your lordships because filed today morning.
you want it to be decided.
Yes.
All right. Take out case law condonation delay, my pen drive. Condonation delay, sufficient cause, liberally construed. 87 Supreme Court 1353, all those. We will have to write that after hearing you. So, learned senior counsel for respondent number 1 submits that he has filed counter to IA2 of 2023 and application seeking condonation delay of 245 days.
Yes.
In filing the appeal. What have you written? See. Counter today, counter today, how line below, however, same is not on record. Office is directed to place the same, place it on record, 19/8/23.
obliged.
Order may be extended.
Interim order, if any, shall continue.
Obliged.
11 and 13, I think.
11 and 13 go together?
Yes.
All right, 11 and 13, yes. So 12. Yes, yes.
Before my friend starts,
this. Who starts? Yes.
before my friend starts, you'll also scan partition. I am for the writ petitioner respondent here. Lordship, so please just 1 week time will be granted. I will get it.
Why? Monday is the most auspicious day in the week, where judges have invariably, we go through, but more carefully they have gone through the case and ready. You seek adjournment. Yes, Mr. Why you want not ready?
I have not filed any counter.
This is writ appeal, no counter. Please tell us. We have been asking everyone which provisions.
Okay.
No provision. You can't file counter.
You are for the petitioner.
Writ petitioner.
Writ petitioner.
Yes.
Let respondents 5 to 10 billion of the appellate.
Yeah, they are appellants represented by you, but you have to argue he is seeking adjournment. That's the effect
Because earlier this court granted an order of status quo. And directed the matter.
Continue.
Yes.
Appeal is admitted for hearing. Ad interim order granted on earlier occasion shall continue. What's your name?
PV Ramana for writ petitioner.
For respondents number?
1.
First respondent.
Respondent number 1, prays for adjournment to enable him to prepare the case and argue this.
Let me represent. 14 and 15. This matter the next item.
14 and 15 go together.
Yes, 14 and 15 go together.
I am for the respondent.
I am for the municipality.
So if a building permission is cancelled,
Yes,
one, we are asking a query. Normally, any statute, what is the statute under which the building permission is granted with?
Under the provisions of the Municipalities Act.
No, which provision? Municipality Act.
Yes.
Which act, Mr.?
Telangana
Under which act the which provision?
Telangana Municipalities Act.
There is some provision.
Yes.
Which is that?
Under section 176(9). 176 subclause 9 of the Municipalities Act.
Building permission granted.
The building permission.
And what happens when it is revoked?
Now, the building.
We are asking in the, you understand senior counsel.
Yes.
You can anticipate. So against an order cancelling the building permission, we don't think that a writ petition lies to the High Court at the first instance directly. This is all bypassing statutory remedies and invoking jurisdiction involving land in every petition. Somehow attempt of the bar is to reach this court in a land dispute, and what is the remedy?
There is no right of appeal against the order.
That's what we wanted.
Yes.
So this the order, according to you, we at the court of first instance under Article 226, we will examine whether buildings has been sanctioned, has been revoked in accordance with law or not.
Yes.
This is the submission.
Yes.
And we believe, which is this municipal corporation or council? No, what is the name of local body for which you are appearing?
Kolhapur Municipality.
Kolhapur Municipality.
That is the second respondent here.
All right. So this municipality works subject to control of the government, power and supervision?
Yes.
Or it's on own, independent, nobody can touch except this court. Do you want to say that there is no other body which can supervise the functioning of municipality, and only this court can do so under Article 226?
Yes. I will also bring it your lordship notice.
There, then we will call out the provision, interpret it and say. To be relegated to this statutory remedy. That's the declaration of acting. Each other is only. We'll say that it is not wrong. The revocation was on this president was office. Against an order, revision. Against any order, talking the regional director here. It's not a notice. There must be some other tool. Which provision, Mr. deals with appeal? According to you, against this thing, order cancelling the building permission, you don't have any remedy anywhere.
No remedy.
But thank God that you are saying that 226 and Article 32 you can go, right?
Well, it does. Well, it is so far.
And SLP also you can file.
No, well, it,
Two remedies, but not under the Act.
well, it,
No, we find it a little odd thing, right?
well, it,
We'll find out. We'll find out. You have given the answer. Now it is our duty to find out from the Act how this order can be.
well, it may also bring it to Lordship notice. In fact, one of the petition, the appellate hearing has filed an appeal. Your Lordship, can you take page number 104 of the material papers?
You know what 104? You must tell us what is 100. That's why you are here, right? What is 104?
The order which is passed by this honorable court, what has happened is the appellate hearing filed an appeal. Under the appellate hearing has filed an appeal.
Which provision?
Under section 252.
Then what happened to that appeal?
Then the appeal was dismissed. Against appeal was dismissed.
On merits.
On merits. Against that carried the matter revision before the government. Government has initially granted an order of stay. Then the writ petition is filed with the contesting respondent before this honorable court.
No. What happened to your this thing review before the government under 252(2)?
Well, an interim order had been granted.
Is it pending?
No. Then questioning that a writ petition was filed before this honorable court. And this honorable court, if Lordship, can you take page 106?
Now what is you tell us? No.
This honorable court has said there is no appeal provision or a revision would lie to the government. And then I sought for the liberty to file a writ petition, and that liberty was granted. That page number 106, Your Lordship, can you take?
106.
106.
106 is nothing, it's a docket.
Your Lordship, can you come to it?
It's a docket, 106.
Writ petition number 27954 of 2020.
Next bundle number.
Data page 522, Your Lordship, can you take it?
Next one.
So why your building permission was cancelled?
Well, the building permission.
Because and who are you? Did you apply for building permission?
Well, I just
1 minute. We have read something. That's why we are asking you relevant questions according to us. You may feel irrelevant, but we have gone through. We know the facts.
Yes.
So therefore, we have simple questions. We are asking you who had applied for grant of building permission.
In so far as the appellant here on behalf of the unregistered association, he made an application.
Who applied for building? You say that I applied.
Appellant here made an application on behalf of the unregistered association for grant of building permission.
No. The paragraph 6 of the order says society applied for permission. You did not. You are society.
No. Well, I am only.
You are. How can you fight against your own society, which you are a member, or their cause when they are not illiterate, not poor? They can come.
It is an unregistered association. An unregistered association
Can maintain a petition. Unregistered association can maintain a writ petition. There are case laws to that effect.
Well, either way, your lordships are aware.
No, your building permission has been cancelled on the ground. That's what you are not telling. It's been cancelled on the. Just a minute. We will tell you, Mister. If you don't tell us, we will tell you rejected on the ground of locus, and there is a cloud on the title of the society.
Yes.
You are a member of the society. This building permission under challenge. I mean, you are not a party to this. You have not applied.
Well, I was a
and there is a dispute of title of the society itself. So why this thing create complications and suffer an order of demolition? You may raise construction which he may not like. Or your successor in interest may not like even in case he succeeds. So therefore, why to gift him a house by gift deed that you want to raise construction, right?
Let me put it in the way, because your lordships are too fast for me. This is a case where it's an unregistered association, and the property has been purchased in the name of the convener.
This white sheets not there in a pad. So who? Unregistered association.
Yes.
Pad. No pad is kept every day, no? Pad is kept every day, so I make notes. Not there. Give, man.
Madam, give a white paper.
Give a white paper. Yes. So who is unregistered association?
That is Budhiraj
Fine.
Employees Welfare and Cultural Society.
Every day you keep this here.
And the property was purchased in the name.
No, which unregistered association?
That is
then what is the property?
Property is the landed property admission an extent of 500 square yards.
500 square yards.
And which was purchased.
What survey number? Something land.
Survey numbers are here.
All right. 500. So you are the owner of this plot. 500 owners.
Well, the property was
purchased. 1 minute, Mister. We are trying to understand. So you are owner of 500 yards.
Yes.
This land. Then why did society apply for building permission of which you are owner?
Budhiraj Employees Cooperative Society is the owner of the property. Since it was an unregistered association, on behalf of the association, the appellate here made
No. So Budhraj Association is owner of 500 square yards.
Yes.
Where do you come in? This land was allotted to you by the society.
That was purchased by means of a registered sale deed.
You purchased?
Yes, in the year 1991.
From when? From whom?
From the unofficial respondent here at Pellet.
So we are appellant purchased this land from
the fourth respondent here at Pellet.
Who is fourth respondent?
Lakshman Rao.
This is 4 is Kolhapur municipality in this writ appeal. There is no Lakshman Rao.
Lakshman can take writ appeal by 22 minutes.
R1. You purchased the land from R1 wide registered sale deed dated?
Well, dated 3/7/1991.
Then what happened?
Well, after purchase of the property, we made an application for building permission.
You means, we means who? You should be clear.
Appellant here at Pellet.
Appellant applied for building
permission. Well, on behalf of the society.
No society business, Mister.
Because
society is not involved, right?
And just it. Well,
senior counsel, just a second ago you told us that you have purchased this plot by registered sale deed dated 3/7/91. Just a minute, 3/7/91 from R1, Mr. Lakshman Rao. Then where does the society come so far as your plot is concerned?
Well, may I request your lordship to kindly take the contents of the sale deed.
Some things should be material as representing the society is small. So he says he's stepping into the shoes of this.
Then what at least we should clear on facts.
Mr. Manohar, as I understand.
Yes.
1991, the society claims to have purchased the plot.
Yes.
Correct? From one GPA holder.
Yes.
Not Lakshman Rao, Lakshman Rao's GPA holder.
Yes. Yes.
Let us be very clear on facts. Lakshman Rao's GPA holder, society has purchased.
Yes.
Now, society, in the name of society, a building permission was obtained, and the society was represented by one Mr. X. and
Yes.
permission was obtained and that person is no more.
Yes.
So your client now today, the petitioner who is claiming has been now the de facto office bearer of that society is filed this writ petition not in his individual capacity but as representing the society.
Yes.
This is your case.
So this society offering the building permission acting through GPO.
No, acting through the earlier president,
Erstwhile president.
erstwhile president who is deceased.
They got it when?
But in favor of this person, to become the president. Yes.
Not disclosed.
I know, but
It is not his law.
is not society's plan. And under the locus,
So building permission granted when?
building permission was granted when
Yes, but the building permission was granted on 15/11/2020.
under 2020, the TSB pass was filed by whom, in whose name?
Well, so far as the sale deed is concerned, well, of the name of the society.
No, society represented by
Karanam Mohan Kumar. Karanam Mohan Kumar.
Mohan Kumar.
Well, it's the sale.
May pass on permissions. Yes, something.
Societies agree. Like some case. Yes, no resolution permitting him to. It's better not to ask anything. Yes, please. Now we have got it. Argue whatever you can. We wanted certain assistance on facts, so eventually.
Yes.
Me and brother, we have found out from the record what is it. Now you can go ahead. Whatever you want to argue quickly.
Well, insofar as with regard to the building permission granted in favor of the association, for the subject matter of repetition earlier. A common order has been passed by this honorable court. Then your lordship get it at page number 86.
What happened to proceeding under 180, 145? It was attached.
145 proceeding, the next case, where this honorable court allowed the repetition.
And this dispute pertaining to actually spending where between the society. Yes. In society and between society and the owners. Who are they?
they are the fourth respondent where Mr. MS Prasad.
You are R4.
R4
Yes.
and in one case and R1 in another case.
Writ appeal 522 is his writ
OS
appeal.
number, OS number is 126.
Yes, there are two suits.
126 of 2021 and
Yes.
2 of what is the other suit?
117 of 2020 and 11 of 2020. You will also get page 90.
117 of
2020.
2020.
And OS number?
11 of 2020. 18 of judgment, my lord, you will also get those details.
Fine. These are two civil suits where the question relating to title under this is pending.
My case is, my lord,
Petitioner is not a party to that suit.
he is not a party. Society is a party. Represented by president. You will ask me for a minute, my lord, come to para 6.
1 minute.
Yes.
Appellant not a party to suit.
Individual.
And society is represented by its president.
Yes, my lord. The name is also there.
What is his name?
K. Mohan Kumar.
The name is, my lord, P. Nagarazu.
Uh-huh.
P. Nagarazu. Nagarazu.
And
A 78 of the bundle.
what is the appellant's name?
Kumaraswamy. One more fact, my lord. Para 16 of the judgment of the learned single judge under appeal.
Let me also take.
He is right. We will hear you. We just want to, you are not,
No,
you did not assess, tell the facts. So we have gathered it and we, of course, we will, it can't be, order cannot be passed without hearing you. He is just assisting us with facts. So, Mr. Taylor,
Para 16
what para 6?
of the judgment, my lord, under appeal.
So, what has been held?
They said petition is not concerned with the society, has not filed any scrap of paper before this court to substantiate that he is anyway concerned with the society.
No document to show that either concerned with lot or society.
Yes.
Or, correct. Yes, please.
Now, my lord,
Lord, can you take page number 36, minute? Page number 36, minute. And this is the notice which has been issued by the municipality under section 176, 9 of the Municipalities Act. And if your lordship can see the Prithviraj Employees Society Cultural Center convener represented by the General Secretary T. Kumar Swamy. And T. Kumar Swamy is the appellate before lordships. And then your lordship can come to page
Now, where is T. Kumar Swamy? Where did you read?
page 36. That is proceedings number 173.
This is what you have filed the rate petition.
I filed a rate petition, and no objection has been taken with regard to the locus insofar as the appellate hearing is concerned in questioning that. And then
Mr. Para 6 learned single judge has recorded a finding that you have not filed a scrape of paper to show that how you are related to the plot and what is your relation to the society. It's not your case that society is hand in gloves with respond number 4, doesn't want to contest. And therefore, since I was some office bearer at some point of time, I will fight this case on behalf of society. Where is the resolution authorizing you to contest on behalf of society?
I have also stated, insofar as the appellate hearing is concerned, stating that being an unregistered association and the appellate being the secretary is exposing the.
There has to be a resolution, right? There has to be a resolution authorizing you. And we have case laws to say that unregistered association can also maintain the writ jurisdiction from time to time has been expanded and it is made available to all sorts of litigants appearing before this. This is argument, it is unregistered. Therefore, I will contest on behalf of society. This is the submission, right? Unregistered association, therefore petitioner has right to.
People worships are not agreeing with
me. No, please argue. We are testing. The first submission is petitioner, the association is unregistered, therefore petitioner has locus to file petition.
Yes. Well, even the
second submission.
Well, even the notice which has been issued by the municipality is insofar as the appellate is the individual capacity, stating that is the secretary of the association. Page number 36 which I have read, and your lordship can come to page 38.
Notice dated.
Well, dated 25/10/2021.
It says 15/11/21, page 35.
36, 36.
36 is no this thing. It is continuation of 35 in our copy.
Your lordships are taking the 522 minutes.
Page 522.
We are this thing 554 we have that is listed for
522 minutes.
522.
You should tell us in the beginning.
Apologies. At page number 36.
Notice dated 25/10.
25/10/2021.
Issued by
Prithviraj Employees Society Cultural Sangam convener represented by General Secretary T. Kumar Swamy.
So, for what was your tenure as General Secretary?
Yes.
This society. What was your tenure? When were you elected and what is it for a lifetime or what? When were you elected as?
Well, that details have not been mentioned.
No, you have to mention.
Not mentioned.
You should know, right?
Yes.
Tell us. When were you elected on the post of General Secretary and what was the tenure of your office as such?
Well, if those details have not been mentioned, so far as the appellate here is
that means it's not there. All right.
And then you automatically come to page number 30.
We can infer that safely that it is expired because you are not telling us. Is he the General Secretary?
Well, even the present General Secretary as of the date when he has filed. And even is continuing as on today. But page 38, if you not can you take
T. Kumaraswamy, General Secretary, Mudinaj Employees Welfare.
Yes, that was 21. That's why the next question. Longer.
There is no resolution also of the society authorizing your client to represent the society.
Because
No, a straight question, right? What answer? Are you still continuing as General Secretary?
yes,
Where is the document?
that's the reason why I'm saying without document, I can't support it, but he is continuing.
You have to then, it is, you have been thrown out on the ground of locus prima facie. It appears as to be correct. You cannot fight this thing battle on behalf of a society claiming yourself to be this thing. This, you have to show us the date of election, when you were elected, when your tenure came to an end. There is no resolution. We need not go into this, right, actually. So you said, senior counsel, we have understood two submissions, 1 minute, two submissions that this thing, society is an unregistered association, therefore you have filed the petition on behalf of society. Second is that this notice dated 25/10 was issued to you by this municipality describing you as General Secretary. And therefore you are entitled to maintain petition.
And even in the earlier litigation, which was there, between the society, between the society and the municipality. The appellate hearing was representing I filed a writ petition before this honorable court.
So next point, we have understood, right? 2 points we have understood, we have told you. Third.
Worships are very fast.
No. Not question. We have to. No. Time of this court is precious, senior counsel. Time of this court is precious. That's why. And we have done the homework, not that without reading this thing. We have read it.
See, if your lordships are not agreeing, so far as the contexts are concerned, lordship may permit me to withdraw the writ appeal also, giving a liberty for the association to question the order.
Correct. That is correct.
Because
both the appeals.
No.
Yes.
In one appeal, it's
One appeal is filed by me. I filed a writ petition.
1 minute.
Yes, sir. Yes. Yeah, I can withdraw both.
Your appeal is Mr. Which? Your appeal is senior counsel.
No, both are his appeals. One writ petition filed by me. He can withdraw the writ appeals.
He wants to withdraw which appeal? We have two appeals. What is the number of your appeal?
The first one is item 14,554.
554 is your appeal.
Yes. Even after cancellation of the permission. Yes.
This intra-court 522, madam, 522/2023. This. Maybe you come here and enjoy this, what we are doing. Then you will know that we will stand there and every sentence you speak, we will interrupt both of us. Then you will know how difficult it is to. We are hearing you separately. He is withdrawing the appeal. Are you opposing that prayer? He can't withdraw.
Again,
End it. By which petition has been dismissed. Paragraph learned senior counsel.
Which is there.
Yes, now your appeal, Mr. Counsel. Yes.
No, it's appeal made, I am the petitioner.
Your Lordship, can you take bullet page number 8?
Like this appeal also filed by minutes.
I think it's 524. This is 554 is this petition. No, this is what I have written. 39. We have passed the correct order. Yes.
And
You have filed this appeal?
yes, now bullet, your Lordship, can you take bullet of the respondent bullet in the writ appeal, writ petition? Lordship, can you take bullet
1 minute.
the cost title in the writ petition? It's again bullet T. Kumar Swamy, the sixth respondent. Son of Patrick here.
That is he has withdrawn. What is this for? What is this?
To remove the illegal encroachment. No. Makes it. Filed by Mr. Mark, where they form legal encroachment. So this was allowed by
Sixth respondent. Who's sixth respondent?
this is
There he has to be heard. The addition, the wasted.
so let's say this it is being the first starts it was the first position.
We will see this. Yes, Mr.
Even here, bullet, the association is not made a party. Bullet, if your Lordship, can you take bullet so far as the sixth respondent is concerned? Again,
No,
bullet,
Mr. One thing we want to understand, like, it is not your residence where it is
it's the society.
society. So society will take care of it.
No, because bullet, on that note, this also should go because not reading of the
that's
corporate SRE party.
Yes, yes.
Even on that note, the.
Yes,
order
we have
must be
heard,
repeating
we have
the
heard,
site.
mark the presence, this intra-court appeal Correct?
Pleasure.
Happy?
No, but as a matter of fact, my lord, before the learned single judge, documents were filed, photos were filed where the appellant was present while construction is happening illegally.
He is disowned. You have now.
The documents are before your lordship. Photos are before this.
This is what he has said, that he has not done it. Now this thing.
Actually incorrect. Say perjury, my lord, because the documents show that he has constructed.
No.
The construction is by the society, not by Kumaraswamy person.
That's why he has said.
You see, in his writ petition, he claimed as representing the society. So if at all it's an illegal construction by the society, now since we have held that he has no locus standi to represent the society, unless until he establishes his locus standi, then that's a separate issue.
Or, yes.
Paper with petition counters were filed, my lords, on Saturday by giving additional documents. Should I have got next week, my lord, so that I can file my petition.
Survey was conducted.
Yes.
GP.
Record.
Yes,
Available.
The relevant page where
Yes,
notice is issued
Notice.
to them.
You mark that page and show that the notice is given to them and
Page
it has been
25 and
received.
27, no? They were affixed on the Gram Panchayat also, my lord.
Huh?
Gram Panchayat.
No, was it served on them? The main case, that only, Mr. Srikanth.
Their names were not there in the position, I mean, Pani Patrikas, my lord.
Whether notice of survey was given to them or not, that was the.
It is affixed on the Gram Panchayat and also the
Not
persons
served.
who are.
Do you carry out fresh survey after notice?
Subject correction, my lord, you should take the metal papers page 2 and file with the appeal.
Page 25 and 27. The yellow
So
color flag.
after Mr. According to us, very simple thing, right? I mean, the authorities can conduct a fresh survey after giving notice to you people and him also.
The thing is that he has filed a suit for it. Now he has filed a suit for declaration.
No, he is claiming some sort of a right and we are not holding that he is the owner. We can't declare his title, that will be adjudicated.
Page 20.
But being a person who has some interest in respect of this property which is claiming, which may be useless also, right? Supposing if you start claiming some title in respect of this High Court building, what can we do? Can we prevent you? No. Let him participate in the survey. There is nothing.
Thanks, this were admitted. Your worship, can see paragraph 3 of the writ of will.
No. So therefore the land, just a minute, therefore the land in his possession has to be surveyed without giving notice to him. This is the submission, right?
My submission.
No, Mister, we are asking you a simple thing. I mean, this is an innocuous order, not expressing opinion. His grievances, no notice has been given to me. The government
25.
advocate says that it has not been given. Giving it to Gram Panchayat is not a service.
So it is. Your worship, right, will not subject to correction, will not be granted. Your worship has seen the notice. The first notice was served. Second notice, because his name was not recorded. Therefore, they've taken steps to not inform them and also pasting on the house of the owner and in the Gram Panchayat. Your worship,
Yes.
see based.
Page
You said
25 and 25.
Panchayat.
Yes, madam. Page 25.
Mister, why are you afraid of taking a stand? You should say that notice has been served to him. This is
Yes,
what is the acknowledgement.
Yes, madam.
You are saying Gram Panchayat.
It is also affixed on the Gram Panchayat, Lord. It is also affixed, and the persons in possession who are cultivating
Mister,
the land.
supposing if I get a notice affixed against you in Gram Panchayat and start recovery of 1 crore from you, what will you say? I will say that I had affixed in Gram Panchayat.
The reason, my lord, the persons whose name was mentioned in the PAN is no longer, my lord.
The occupier has been served. Your worship, just see,
The occupier of the subject certain bits in Telugu.
6/2050.
So when was the survey conducted?
Survey conducted, as per the Panchanama.
6/7/50. According to you, when the notice was served? When notice was served on him?
First notice of
June 1, on 15/6/2015, it was served.
Huh?
15/6/2015.
15 or
15/6.
served.
Sir.
and also 1/7.
And therefore the order need not call for any, doesn't call for any intent.
What?
This is the submission.
Against the not an appeal license to the survey authorities. Appellate authority has not preferred appeal. Large judge on the ground also said you could have preferred appeal. Third is that when he suppress the filing of the suit, Your Lordship, a suit is filed for declaration, cancellation of my sale deeds. And 3 is that, if the requirement of, he has admitted that I am the owner. His land is not surveyed. It's not his case that, I am not the owner and his land has been surveyed.
This statement should come from him. We will dispose of the appeal right now.
The government.
What is your survey number, Mr.?
144, the entire survey number is 144, but they are the petitioners are brothers.
No, 1 minute. You told us no that he is not concerned with the survey. So we will have to extend.
I don't think so. He's having the 11 acres and all, I'm having the 11 acres lot, and the petitioner.
So you concede that the no survey shall be.
They are saying that they are not conducted survey.
No, we will.
These papers are not.
Sir, we will record their submission. They will be bound by it. The government, you will not carry out any survey of land in respect of his possession, correct?
Yes, no, that has been recorded.
And it has not been done. The only survey of
11 acres
his land has been done.
Yes.
This clarifies should.
Para 8 of the judgment. That is observed.
No, there's nothing to adjudicate about, right? You are being more than fair, government advocate and you. So there's nothing, we will record their submission and dispose of this.
I'll take instructions with respect to that.
What instruction?
But because my lord, the papers which have been given to your lordships, my lord, that has not been given to me. I don't have the.
Is a record.
Record, my lords. I don't have the record, my lords. My whole case was there was no notices given, my lords.
1 minute.
We only wanted record to be produced to see whether
Notices
notices
were
was served on
No.
you or not.
My lords,
Because that is what we have recorded in our previous
Mister,
order.
please understand, even if it is not served, doesn't make any difference because it is not in relation to the your land
My lord,
survey.
I'll get instructions. Well, lordship may have it at pass over, my lords, if your lordships are not in.
What instruction?
I take instructions from my senior with respect to that aspect.
So what did you understand?
But so lordship.
No, what did you understand?
But it's by contentions of my seniors. my lords.
Nothing
They're saying
contention.
that the-
Simple thing is, they are saying that the survey of a land has been done with which you have nothing to do. And they will not conduct any survey in respect of land measuring 11 acres of survey number 144, which is in their possession. In recording that statement, we will dispose of the appeal. Do you get it?
Lordship may have it in pass over, my lords. At 2:30 I'll.
So there can be 230 or 130, we don't know, but pass over.
Yes, pass.
Why? We have repeated so that you understand.
Yes,
Otherwise, you will say that I didn't get it.
No, my lords. I'll come back at 1:30 or 2:30, my lords. Whenever you're talking, lordships are taking it.
Got it? No.
Yes.
Your grievance does not survive because it is surveys in relation to their land, not this thing.
Yes, my lords. I'll come back at 2. Whenever your lordships are taking a pass over.
144 by A3 and 144 by B2. What are the extents of this?
The subdivisions have happened.
His own affidavit, para 3 lordships.
No, what is his survey number?
But the whole trouble is, my lord, the subdivisions have happened.
That's why I'm saying.
By what?
today, 144 by A3 and 144 by B2 is the survey for which notice has been issued.
But
What is your subdivision number?
my contention is, my lords, my survey number is also same. However, because of this subdivision which
You
has
are
happened
also
subsequently,
144A and 144B2.
by virtue of this subdivision, my lords, a new subdivision has been created. A new land has been created where it is
B2. B2.
Yours is B2.
B2.
Then if it is A3,
A3 and B2. A3 and B2.
that is yours.
Yes.
But extent is not mentioned. Total extent is not mentioned in the notice.
Put it in the affidavit.
No, in the notice that is issued by the
But
survey authorities.
this very statement you can make when fresh survey takes place. That revenue authority in 227(6) in writ appeal can be decide where 144A3 is situate, where 144B2 and what are their lands and where are they located. He's saying 140. So we thought that it's a very innocuous order that after giving notice to all parties, survey will be conducted. You point out at the spot to the revenue officer that I am not claiming his land. End of the matter. No, but what is, Mr. We want to understand what is this thing. Resistance for a fresh survey with this unable to comprehend. In the lighter vein, since once you have managed so difficult again you to manage. Therefore,
He's submitting by extent, I'm admitting by extent. The father of that will It's not the question is that, because already we are notice.
All right.
Suit has been filed, no appeal is filed against this order. An appeal lies under the service regulation.
We have understood that against an appeal lies against, we have sole ground we have entertained is no notice. You all right, you want to contest, we will decide. He is seeking a password.
Obliged, my lords.
We thought that we are making some reasonable proposal offer to you, which you are, according to you, it is unreasonable. That order cannot be set aside. We will decide it.
That will not only by the hand is appeal.
Password.
Obliged.
You be here, Mr. Whenever it is called. We don't know when it will be called.
I think something needs to be before that we found it.
This shows no, they served on them or not.
No, it is a fixed on the ground fund, which is not served on. It's same because the name is not in the revenue because they have not.
Morning I filed an
Election is chief. He has managed by the post.
There should not be any.
Huh?
Or yes, periodic survey.
At least that survey will bound a multiplicity of litigation it will avoid. 1 minute. That's it, then we need not hear them any further. We'll set aside the order. Yes, 17.
I'm for R4. Okay. On the last date of hearing, they filed additional documents along with the writ appeal. Today morning, I filed a counter.
Yes.
One is IA2 is to receive
Yeah,
IA2 of
yes.
23, right? And with 2023, 2 of 2023 is all receive additional. We have already committed scale. Additional. So that would know.
But Saul, it is because of his objection, right? You have filed.
Yeah, today morning we filed. Friday, the copy was served in the afternoon.
What happened, Mr. District Collector Malkajgiri? What is he doing? There was an order directing him to pass appropriate order within 8 weeks. And you understand how many weeks have been passed. So do you want us to issue suo motu notice of contempt?
But I'll get instructions by whether.
He has to
orders have been
decide.
passed.
There is
Yes.
no, this whole litigation is still pendency of proceeding.
Yes.
These people are filing documents and he doesn't decide. What is pending before collector, Mr.?
The order was originally the.
What is pending before collector?
So the matter has been set regarding the disposal of to whom the patta passbook has to be issued. It's pending before the collector. So the order was set aside. To both the parties, patta passbook was granted. Ultimately, for the collector to decide.
He has to do it within 8 weeks, Mr. 4 weeks have passed.
By Monday, we will get the instructions. By Monday, I'll get the instructions. Saturday.
Learned issue government advocate.
On last occasion.
We are not doing anything, Mr.
On last occasion, Lordship has heard and granted interim orders to me also.
So be happy then. Be happy.
Interim order in your favor, we are only.
You are arguing as if, how did you know what sort of an order we are passing against you?
Because that is being adjourned, but I thought I have to bring it to our Lordship's time notice about the passing of interim order. Because interim order.
This is the order which was passed last date of hearing.
Yes.
Do you mean to suggest that we don't know what orders we pass?
Yeah. This interim order was only till today. That is what I want to bring it to you. Just to represent that.
Learned, whatever, GP for revenue.
Maybe. Internal auditor application is. We have filed counter today morning, Your Lordship.
Huh?
I'm for the petition of my lord. The counter is just now circulated.
Learned counsel for the petitioner submits, learned counsel for who submitted?
I have
After-
counted.
R1
R1.
You are ARC.
No, State Bank of India.
Also then para 9 he has said that he is ready to register.
Yes. Just may I submit an important aspect, my lord. Even in the counter, your lordship may kindly see.
Para 9.
They have even stated. May I read, my lord, in the counter, afresh just filed.
No, you want time, then seek time. If you are ready,
My lords,
read it.
Full or you have paid only 25%?
My lords,
No, simple question. Have you paid the full or 20%?
full amount, my lord. We have paid full amount. The issue is without clarity on the.
No,
title of the
you
bank.
want encroachment to be removed, area to be fenced and then hand over possession.
My lords,
That was not the stipulation in the sale notice.
Yes.
It
My lord,
must
that
be
is-
as is where
the
is.
the sale notice itself is bad in law, as the reason is they have not.
Then you
disclosed-
go, then if the bank will refund the amount to you.
That is what only I am asking, my lords. I filed an application before the court only to refund the amount.
Yes. You refund the amount,
Yes.
right? Why
I'll
to
take
this?
instruction.
Correct.
Yes, my lord.
Amendment you have
take
filed.
instruction.
Amendment is I
You
filed
got
to.
instruction.
They are asking
Even
interest part which is higher, 18% interest,
no.
but it cannot be.
No,
given.
whatever refund.
Plain refund can be
Uh,
given, your lordship.
Give a.
refund with interest, my lord. For the last 4.5 years, I am suffering with that.
They are saying.
No, when did you pay the first? You
Full
paid
amount I paid, my lord.
You paid 25% and one immediately on auction.
18.
Balance the 3 point odd crores. When
Amendment.
did you deposit?
That is immediately we learned.
No, it's not immediately.
Huh?
That is immediately we deposited, my lord, within 15 days time.
Mark the
My
mark the
letter is
presence.
there, your
Just a
lordship,
minute.
on page number.
Mark the presence heard on IA number 1 of 2023 for the we are entitled to recover the amount
Yes.
from him and not also to register the sale deed. You can say so. We will record it. Then we decide what is to be done. Huh? You can say that I don't want to refund the amount. I will not convey the plot to him also, and I will recover because he dealt with me. How did he dare to participate with in a auction held by State Bank of India? So since he has associated himself with State Bank, therefore he must suffer for all times to come for remainder of his life. This is mission, right?
If at all I am at wrong, my lords.
No. That's the again.
Yes,
Either way, that is the submission of the bank.
Yes, my
They bank people by their conduct tell us that don't come to us, don't take loan from us, we will harass you like anything.
lord. This is
And more particularly this gentleman who is representing the bank, correct?
That is not so, your lordship. This is the bank who has supported the whole country at large.
They are not serious about it. You are taking it serious like
No,
you have sought time to seek instructions. We are giving you time. Petition is admitted for hearing. Learned counsel for respondent bank praise fund is granted. Yes,
my lords may post the matter for
No.
hearing on next week, any day convenient to your lordship.
all this can't be done like
Because it's only
My money is stuck for the
No,
last
you said-
4.5 years, my lord.
We will have to, you bring the case law.
Yes, ma'am.
Find out, we will have to,
I've read
it's
my-
not very easy, mister. Seeking refund means you wanted to purchase the plot, now you don't want. So
No,
you
my-
can't say, no, at one point of time you wanted execution of sale deed, now you want. We will have to record a finding that they are at fault to, for non-registration of sale deed, then only you will be entitled to refund.
It is even in their counter affidavit, they have admitted, my lords. It is even in their counter affidavit.
It is due to their inaction.
My lords, it is not the question. My
See,
humble
mister,
request
if
is,
the
maybe posted for next week, your lordship. so that-
admitted for hearing, learned counsel for the bank praise warrant is granted. How much time?
2 weeks.
2 weeks time to enable him to seek instructions
Yes.
in the light of submission made by learned counsel for the petitioner with regard to refund of sale amount. List after 2, but admit it, right? Yes.
My lords, amendment is allowed, my lords.
Allowed.
File
Deep
1
law.
week.
File amended copy we have said.
Yes, deep law.
Give a synopsis, mister. If you want everything to be heard, you will not assist the court. And then we can't write without this thing that now you want sale consideration, therefore such amount 18%, 24% interest directed to refund. This order can't be supported in Supreme Court even if it is granted today.
Even
For this, we have to say when auction held, when did you deposit first installment, when fourth installment, what according to you, why the sale deed was not executed by them. You have to prima facie demonstrate that it is on account of their inaction or negligence.
Yes.
Then only you are entitled.
Yes.
We have to write all this.
Recent.
And you think that if you get an order, he will refund the amount.
Yes.
You will have to accompany him to Delhi. Even if a Group D employee is some benefit is granted to them, they are chronic litigants, they will go to Supreme Court.
My lords, they are habituated to it, my lords, because they are supporting the.
Because like they are litigating at the cost of public money.
Yes, my lords.
So maybe you should realize this, mister.
My lords, my humble submission is recent.
Repeatedly it can't come up. Second time it has come up before me.
Yes. Recent Supreme Court, even in Leela Matthews case, Supreme Court has upheld, my lords.
Bring that decision.
It is there.
And annex with your
Yes,
synopsis, 1 page, annex that decision, paragraph. This paragraph of whatever, Leela, not whatever.
Even next week, your lords may convenient, I will.
He has to get instructions from
Yes,
Bombay.
yes, yes, ma'am. Deeply obliged.
Order. Yes, Mr.
Item 19, I have for the petitioner.
Fine.
Your Lordship may decide this matter in terms of section 12, my lords.
Yes, we are allowing the writ petition. You don't have
Yes.
in this writ petition, comma, the petitioner has assailed the validity of the notice dated. Which notice, Mr.?
First notice at page 20.
30th 9, 2021, issued by Telangana State Human Rights Commission, herein after referred to as the commission, by which petitioner, who is the husband of respond number 3 has been served.
Yes, my lord, sir. He did not disclose here.
By which the petitioner, who is the wife, has been asked to appear before the commission in pursuance of a complaint made by her husband, namely respondent number 3. Madam, you mark everybody's presence and say she appears for 2 and he appears for 1 and none for respondent number 3.
Division by judgment of this court, my lord, concerning section 12, my lord, regarding the Supreme Court judgment.
There is a Supreme Court judgment.
Yes, my lord, 2014-15 SEC 197.
We have passed orders. That's why without hearing, she also knows what it is. That's why nobody is arguing. Yes. Paragraph. Facts giving rise to filing of this petition briefly stated are that Yes.
20 also goes the.
My lords, I'll make some submission in this matter, my lords. I'll make some submission in this matter, my lords. My lords, the maintenance is nothing but food, clothes, shelter to women and children who were deserted, my lords.
It's same.
My lords, the
Same
my
parties, no, but same parties. Different.
this is the maintenance case, my lords, wherein maintenance was granted.
No, then, madam, why then 125 CRPC, 24, 25? So the courts have jurisdiction in these statutory provisions to award maintenance, even under, what is that, this Domestic Violence Act also.
Yes.
So DV Act also, everywhere in law provision is there. Then those courts should be abolished, right? And Human Rights Commission should be empowered to determine the quantum of maintenance.
Yes, my lords, I'll submit some judgments of Delhi High Court and Supreme Court, my lords. In Kusum Sharma versus Mahendra Kumar Sharma, my lords, I may be permitted to pass these judgments, my lords.
Yes.
My lords, in this matter, the honorable.
Not cite in earlier case, Kusum Sharma and all that. Earlier case, we allowed the petition just now.
It was the relating to visiting rights of a father, my lords. Now this is a maintenance case, my
I can
lords.
write there, made a complaint against so and so, huh? You have written, no? Respond number 3 made a complaint against.
Not only a legal or statute right, my lords, it is equally a human right of every woman and children, my lords. On this, my lords, I'm referring a Delhi High Court judgment. I may be permitted to read para number 9, my lords, second page.
Make a submission, your lordship, with your permission. It's in a dispute. It's in a dispute between the brothers' families. It's not a family. Wife and husband, your lordship.
What has happened? This. So she has filed a suit. Claim,
No.
her claim for maintenance is pending before any court.
No, your lordship. See, it's only maintenance awarded by the HRC to the brother's minor son. So I'm a small businessman, and after the COVID, my business is not running. I'm running the Mirchi Bandi, and HRC is not considered my fact during the time of the arguments, and awarded the 5,000 rupees to minor, my brother's son.
Brother's son is your nephew.
Nephew. Yes, your lordship. See, I'm starving with the after COVID effect, and I'm not able to run my family.
No longer in this world. Is he there, your brother?
Yes.
Then, so how claim his father is there? No child's father is there to look after him.
That's true. According to section 18, HRC has the powers to direction only, not to compel pay the payment. Your lordship aware of that thing. Earlier orders, HRC, your lordship has passed an order. I'm only on that ground.
What ground? You are not challenging order passed by.
Yes, I am
not challenging.
Yes, I am challenging the order.
Then what you say only on this ground? What ground? We are listening. Go ahead.
HRC has only to direct the petitioner only, to direct the concerned parties to and suggest this thing only, not Madam, please read page 13, the order passed. How does it come within the purview of section 12? Tell us.
Yes, apology, my lords. I don't have papers. I only obtained the copy of.
Mister,
copy
give
of
it
the
to
order.
her.
Read the paper.
Give to her.
Ask her to please read
Your-
page. Mr. Ramprasad, you have page 13?
Yes.
Please give it to her. She is defending HRC's order. Please ask her to read page 13.
Petitioner along with the grandmother is present. Petitioner's elder uncle and his wife are also present. The case of the petitioner is that the petitioner has lost his parents. Consequently, his elder uncle Santosh Kumar and his wife took care of him prior to the last 2 years, and for last 2 years he is staying with his grandmother. His grandmother stated that she is an old lady and his grandson is studying and she does not have any means to give his grandson good education. Therefore, the petitioner's uncle and aunt are responsible in maintaining petitioners because the property secured by the parents of the petitioner is being enjoyed by the petitioner's uncle and aunt. There is no dispute about this. Mr. Santosh Kumar, uncle of the petitioner, and Santosh Kumar wife says prior to 2 years, the boy was brought up by them along with their 4 children. They said that out of the earnings made by them by way of rents, they will take care of education and maintenance of the petitioner. Mr. Jeshwant Kumar, that is the petitioner. They said that 5,000 towards every month maintenance, also annual fee to be paid.
Where is the order by the State Human Rights Commission directing you to pay 5,000 per month?
Page number 11 and 13, Your Lordship, I have filed neat copy number 13.
Read from which page neat copy, read it. Where does the commission says that you pay maintenance?
Uncle of the petitioner, petitioner Santosh Kumar wife says parade.
Whatever, Mr. We hope that you have read it at home.
Yes.
Page 13, you have read it. We want to cut short the time and say that there is no order directing you to pay maintenance. Whatever they have said, it has been recorded. They said, right? And thereafter said, matter is to be directed after 3 months. There is no order by the commission directing you to make payment of amount of maintenance. You go before the commission, tell him that you don't have jurisdiction under Supreme Court order. He will decide. Why have you come here? The commission issues notice, you rush to this court. Why? Because you want to keep us busy. No work.
Already we have make a submissions. After that only they have passed this order, Your Lordships. After they arguing the matter only, just they have passed this order. That is the reason just we are here. There is no other vote.
May I assist, Lordship? Lordship, in the interest of the child, with the record which disclose, the child parents both are died. So therefore, Lordship, my request is to direct
You are
the third respondent.
He is your nephew, right? Your brother has expired.
That's true. Even not.
Why does it take them to approach the commission? You are an uncle. You are his uncle, and that boy must look to you, must be looking to you as father after he has lost his father.
That's true.
You are contesting this litigation. I mean, you maintain him, poor person. You will get something, right? I mean, if you look after him as your son and this thing.
See, one submission.
Instead of contesting, you take this responsibility.
Only on humanitarian grounds and
humanitarian grounds only.
Only I am doing the
not humanitarian. Humanitarian, you this thing, when somebody is not a member of the family, you are going across the road and you help someone.
Please bear
He
with
is
me
a
one
member
second,
of
one
your
second,
family.
Your Lordships.
Where does he,
Even
where does he stay? Where does this boy, minor boy stay?
with the grandmother.
Grandmother.
Yeah.
Grandmother means your mother.
No, no.
Then
Also. It's mother's mother.
So
That's
that is
maternal.
taking
You
care.
say maternal.
That's-
So, your Lordships.
No,
only my-
you seek, mister, you seek instruction from your client, how much he will contribute to the child's this thing. And then we will, these cases don't contest, mister. Stop. Here you, this thing, yeah, you have to be
only one
some,
submission.
like, some, he is an orphan boy belonging to your, this thing. He should not be first place called an orphan because you are there as his uncle. And you don't incur his grandmother is taking care of him. Give something to him. What is this contesting? This law, etc., we will decide. But this is not a case where you say, you should volunteer. If not 5,000, how much?
See, he has been living with your 4 children already earlier.
Don't contest it.
The largely violation of Article 21A, right to life as education of the child, because within a minor.
Fundamental right, then what, the government? Make a claim from the government, fundamental right.
Otherwise,
He is your uncle.
yes.
You want to contest? You didn't hear what we said.
Yes, I understood.
He will make a statement, how much he will contribute. And in case 21A article violated, the remedy is not uncle. He is not state or instrumentality of state.
Yes.
Don't invoke article 21A against him. It can be invoked against these people who are sitting quietly. Mr. GP for revenue. Against you, the article 21A can be invoked. Correct?
The petition negligent, then he has an option for, I am for the government lordship, therefore carrying the responsibility.
So you are saying that the right of child is violated and you will provide facility?
Yes, Lord.
How much? Tell us.
The lordship.
How much amount will you pay to the child per month?
About his education and after government will provide, sir. That is, I am just
Only one sufficient.
Free education. Up to 14 years.
Yes, sir.
That's his fundamental right. Very good. We thought that you are appearing for that child. So you should say that I am representing government.
GP for social welfare.
You should say so. Right? That's why we made you stand. We thought that he is appearing for the child. Madam is for Human Rights Commission.
I am so sorry.
So we thought that he is appearing for this.
I am for the respondent for one.
Say so. So you will provide free education. See how your nephew. Are you not happy?
I would like to submit one submission, your Lordship. So I leave it to you.
Don't-
Only after COVID effect, I am running the Mirchi Bandi business.
No.
Nowadays,
Please understand. You are the uncle of the child.
Yes.
State wants to provide free education up to the age of 14 years to him. You should be happy or not?
Yes, very happy.
Happy.
Yes, definitely. Yeah.
And you find out from your client what he will do. Whatever we will record it. This writ petition, in this writ petition, the petitioner has marked their presence. Don't tell us that I can't find out where a young boy is studying. Huh? No, nothing. Find out and tell us.
Almost.
Oh, 3 weeks, your lordships. 3 weeks.
Right, 3 weeks.
Yeah. 29th August.
I'm ready to pledge.
My counter affidavit, my lord. I'm appearing for the first respondent. I have filed my counter affidavit.
You are for the petition.
I'm for petitioner, my lord.
Ah.
The petitioner of the senior citizen.
No, Mr. Where is the order allocating their services to state of Telangana? Andhra Pradesh. You have said in para 5 of the counter.
Lord, sir.
No, is this hospital apportioned 5842?
No properties have been apportioned till now.
Then,
None of the properties. Not only hospital, any of the property.
then how do you say that they are not entitled for treatment? If Telangana employees who are allocated to Telangana are entitled for treatment, why is that employees who are allotted?
Find out, Mr. All cases are not to be contested. Yes.
Medical and 75 minutes.
How many members, Mr.
You have 50 minutes.
No.
Out of 250, 30 people have passed away.
Also, as per the counter affidavit of the second respondent also, my lord, that they have established a dispensary here and they are providing the medical facilities, my lord. It's not that they are not providing, my lord.
Dispensary is different. Dispensary is to hold this wrist and see whether I am suffering with fever or not, some give medicine. But medical treatment, it's a 30-bedded hospital, if I recollect correctly. Tarnak Hospital is a 30-bedded hospital. If the assets have not been divided and it has not come to Telangana, it continues to be a joint property of both the corporations.
Learned counsel for the petitioner submits. This petition, which
Subject to your lordship's leave, Lord, I am instructed by the learned counsel appearing for the petitioner to appear in this matter. I want 1 week time, my lord, for preparation. Day before yesterday, papers are.
you should find out what is the order dated 19/5/2020.
Counsel is.
No.
Yep, my lord.
You are senior counsel, right?
Yes.
19/5/2022 is an order passed by the Debt Recovery Tribunal under SURFACE Act.
Yes.
you know Satyavati Tandon and latest judgment
I
of
want
Supreme Court.
some time, Millard, to prepare because it's a voluminous record is there.
No, no, there's no
Council is
voluminous-
also made available.
No.
Man,
We are saving you the trouble of not going through the voluminous record. You tell us that you have an alternative efficacious remedy
no,
under
no,
section
because-
17 or not.
Millard,
Order is not
that is
applicable.
my simple reading, Millard.
1 minute.
Yes.
That's the question prima facie in our mind. That's where we
Yes,
is
yes,
the
yes.
so you
Yeah.
start whether this order is applicable or not. And tell us whether Satyavati Tandon has been overruled by Supreme Court and has not been sub. It's a 3 judgment decision. It is, we are telling you overruled, we are telling it's not been overruled. And that is 141 binding on us.
I will prepare according.
Also, but this is an order under 13 of the SURFACE Act. Right?
Yes.
13/4/2022.
ERT proceedings.
We are asking a senior counsel. We didn't ask you the question. And in any case, you are trying to answer a question of which you don't know the answer.
I take back.
No, we said which proceeding, or did I ask under which act?
RTD.
23. 23 Supreme Court also. It is under Mr. which act?
SURFACE.
SURFACE.
I will prepare according.
This writ petition has been filed. Mark the presence. This writ petition has been filed against order dated 19/5/2020. Hope he would recover.
Sorry,
what is the element and who is the counsel?
Council understand my last case, I'm suffering for viral fever, my lad. That is the reason.
So today also he is still continuing in viral fever.
Some weakness. That is it.
I will take.
I'm apologizing, my lad.
Time, Millard, without seeking any.
No, there's nothing to argue, mister. We have written. Please argue that Satyavati Tandon does not apply. This 2023 judgment petitioner is not bound. You this argue. Why we are saying so, mister? Every case me and brother devote time and we don't roam around, right? We study in the office and make notes.
Yes.
And you people just, this all people, human effort, it requires to get a case listed. And these people, he's writing a judgment. Again, it will be typed, signed. Again, this file will come before us.
I observed.
And you know the answer. That you should go to DRT. We will send you to DRT.
I will satisfy your lordship, Millard.
Nothing.
The writ petitioners were not party to the.
Any person,
Millard,
it's not a party agreed.
Here, Millard, what happened is I am neither borrowing.
No. You are not neither a borrower nor a guarantor, correct? And this secured asset which is put to sale is not a secured asset and with the bank.
No.
This is the submission.
Yes, I will demonstrate, Millard, with some.
Say so.
Okay. Just 1 week, Millard. I will
19th August.
1 week.
Saturday, 19th August. place for adjournment to enable him to prepare the case. No, once again submits his name that the arguing counsel
Convenience.
Saturday is convenient for us.
Yes. Public.
So it doesn't look nice that, but you tell us, Mr. As a senior counsel, you should, as an officer of the court, you should advise for how many petty, we are taking view in all the cases, right? We have relegated, Supreme Court is there. We are bound. Repeatedly adjournments are sought.
Need to prepare fully well and complete this court pillar. That's why I'm seeking that. There should not be any small defect on my part.
You know, there is an interim order, that's why.
Yes, that's why.
The moment we will vacate the interim order, his weakness will be gone.
Within 1 week, I will ask.
No, today we vacate the order, the weakness of arguing counsel will disappear. Tomorrow itself he will say, I am fit, sir, my case be heard. I will argue for 1 hour. This only because of stay. In any case, we are not continuing the stay order because bank will have to, interim order dated so and so not continue.
Arguable point is there. That's okay.
Interim order is not continued. 19.8.
Yes. 19.8.
Now you don't have an option. Interim order is not being continued.
After 19.8, well,
not being continued because it was state auction notice. The bank must not have taken action.
19.8, Milad. Your last may
Interim order shall continue till 19.8. It is made clear that in case matter is not argued on 19.8,
yes,
the interim order shall not continue beyond 19.8.
Yes, that's public.
All these contentions you can urge in an appeal. The expression any person aggrieved is wide enough to include any person who is not a this thing.
Well, that's, I welcome it, Mira, because
we could have decided it today saying that you file an appeal, interim order shall continue till then. You file an appeal under section 970 and we will continue.
Millard, 19.8, Millard, I will argue, and if not, Millard, I may request you. Public.
Better affidavit.
Spot number 192, Millard.
Better affidavit. None.
Those people that come in, so they will be interested. Young person who do this.
This is a repetition, right? Not PIL. Should we dismiss it?
We should discuss it.
None for the appellant, none had appeared on behalf of the, none for the petitioner, none. Yes, madam.
Sir, just now I referred two judgments, Ross. One is of Supreme Court and one.
No. The complaint was for maintenance.
It was filed by a 7 months. So
No.
pregnant.
She had filed the same complaint. She had sought same prayer before you, which were sought by her in a domestic violence case. So you say that jurisdiction of domestic violence, this court is excluded and Lokayukt alone, Human Rights Commission can alone entertain.
Lords,
That This is not a claim of maintenance. No, no.
And fortunately for her, madam, the domestic case was allowed, madam, fixing some maintenance.
How much?
It was disposed, madam.
How much?
5,000, madam. I'm not sure, madam, but I was told by the Health Court Council.
When?
Around 2-3 months back, madam. Yesterday evening, it was informed for me, madam. My last record it. Maintenance was granted.
Maintenance has been granted by a competent court. This thing, madam, you will not get it. Wife will get it.
Yes, I'll make only one.
Commission will not get maintenance. The aggrieved party has got maintenance. She has the remedy to apply for enhancement. How you can entertain matrimonial disputes? How?
My lord, this is a serious.
There is no, Mr. Where is the complaint?
But
filed by the.
Yes, my lords, may kindly take me lord, page 38, my lord. 30. Is it DVC, my lord?
So this is to the commission.
Yes, but this is to the DVC.
It is a
Same prayer, my lord, at page, my lords, may take.
Don't interrupt, madam. He is telling us, right?
But the page 20 is the, my lord, the prayer. And the prayer part starts from 19 bottom line. Required at least 45,000 per month.
Yes, madam. All right. Yes.
My lords, if your lordship observes the complaint of the complainant, my lords, at para number 8, 9, and 10, my lords. She, at the time of filing of a complaint, she was 7 months pregnant, my lords. She was subjected to cruelty by the mother-in-law and the husband, my lords. She was beaten by the husband and mother-in-law, my lords, and also she was forced to go for an abortion, my lords. In this matter, my lords, if your lordship kindly see, the domestic violence is indeed against violation of human rights, my lords. Your lordship observes the definition of domestic violence, my lords. It includes economic abuse, my lords, which includes, I may be permitted to read.
Don't refer. Your functions have been defined under section 12. Read out which clause it follows. It has clauses up to J. Which clause authorizes you to entertain a complaint with regard to domestic violence? We are not sitting here to give a character certificate to husband that he is very good and wife is wrong. Neither you can do it. We are going by law, section 12, which clause permits you to entertain a complaint with regard to grievance of domestic violence.
My submission is, my lords, the domestic violence itself is against human rights of a woman, my lords, which was indeed a act, my lords. It was on the basis of which the Domestic Violence Act has been passed, my lords. Your lordship sees object and reason.
1 second. Please go to page 19 bottom and continuing to 20 and also see page 38 and tell us what are the prayers.
Yes.
The prayer that is sought is not with regard to taking action for the violence or violation of our fundamental right. Look at the prayer here in page 19 running into page 20 and page 38. Please see what is the prayer. Is it verbatim same? So can you maintain two parallel proceedings? On that ground, it need to be interfered.
Yes, your lordship may decide as per section 12.
He was also charged sheet at 39.
No, it's fine. You are maintaining, you can't have two horses, madam, simultaneously.
Be considerate to your wife. Even though you are succeeding, that will be our advice, right? Yes, in this writ petition, the petitioner has assailed the validity of the order dated. What is the order dated?
It's
7/12.
Yes.
2021.
Notice dated 7/12/2021.
Validity of notice dated 7/12/2021 by which petitioner has been the petitioner has been asked to appear in person before Telangana Human Rights Commission Act on 30/12/2021. Paragraph. Facts giving rise to filing of this petition briefly stated are that marriage between the petitioner and respondent number 2 was solemnized on 23/12/2020 as per the Hindu rights. Full stop. The petitioner and respondent number 2 were unable to lead happy married life, and married life. Full stop. The respondent number 2, namely the wife, filed a complaint against the petitioner under section 498A of the IPC and under section 3 and 4 of the what DP Act? Dowry Prohibition Act. Dowry Prohibition Act, which is pending before 15th additional Chief Metropolitan Magistrate, Nampalli, Hyderabad. Full stop. Paragraph. It is also not in dispute that the petitioner is not in dispute that respondent number 2 has filed a petition before the protection officer under the provisions of Domestic Violence Act, right? Whole thing, right? Protection of women from so and so act, which is pending. The reliefs claimed by the petitioner by respondent number 2 in the petition made to protection officer are read as under quote page 38, 1, 2, 3, 4, 6, 5, 6, page 38, paragraph. Thereafter the respondent number 2 wife made a complaint to the commission, herein after referred to as the commission, opening para you say, commission, in which same reliefs were sought which were sought in the proceeding under Domestic Violence Act. This is what? 25. 25. Oh, 25 is what? 20. Which case? Madam? 24 is over. Over. Chilpatrash is over. 25 is not. Okay. 25. So 25. Okay. This is also
It's to Human Rights Commission.
I'm referring the Supreme Court judgment, my lords, wherein
Like the
Supreme
commission can say that.
Court
Huh?
interpreted section 12, my lords.
Huh?
I'm referring this judgment, my lords.
No, no. So what is your submission? The commission can examine
Yes,
and impose punishment on him.
Lords, a complaint of violation of human rights can be filed against anybody, my lords. Same thing was held in this matter, in this case, my lords, by the Honorable Supreme Court in Punjab State Human Rights Commission versus Jai Singh, my lords.
Give it to him.
I may be
What
permitted-
happens to this is which? What is the citation, madam?
I may be permitted to pass this judgment.
Citation.
Citation, my lords. This is daily orders, my lords. Punjab State Human Rights Commission versus Jai Singh, my lords. Punjab State Human Rights Commission versus Jai Singh.
We did not say what is the party's name. I said
Lords,
what citation.
there is no citation in this matter, my lords. Only this is a daily order of the Supreme Court. Unreported judgment.
And so you have read this G. Manikamma, Rodri Cooperative.
It is relating.
You have read no? Read no?
It is relating to the title dispute. Title dispute. My lords, there is nothing relating to title dispute here, my lords. It's a
No.
technical negligence.
No. So see, madam, they have the statutory bodies under the act. Like if a doctor complaint is made against a doctor with regard to what is that body, Mr. Under the
MCI.
MCI and state level, which is the body which can suspend the license also.
State medical. Already
State medical board.
Already proceedings are before TS Medical Council.
When is being initiated?
She has initiated.
When?
And we are facing here.
When? Same thing. Two remedies simultaneous.
The
That principle.
commission has only directed DMHO to inquire into the issue and to file a report, my lords. If your lordship observes the complaint of the complainant, my lords, there are allegations that she made the
No,
complaint
no.
to DMHO.
So therefore, we will direct you not to proceed further because the matter, the cognizance of it has already been taken by the state medical board.
Yes.
Huh? Yes, Mr. Where is it pending? When? Who made a complaint to this thing?
Appearing for the respondent number 5, my lord. The case number before the TS Medical Council, the case number is TSMC.
Medical Council
of Public 1298. I will forward it to your lordship.
When was the complaint filed against you?
The complaint filed in the 2022, your lordship, November 20.
No date.
I have, that is another file, but I have filed an update before.
No, no. So you don't know the when the complaint was filed.
And
Huh?
I don't know, your lordship. I am.
What has commission done? Telangana State Medical Council, what it has done?
Telangana State Medical Council, he has filed the complaint before the Telangana State Medical Council.
What it, Mr. What the commission has done? Nothing.
Commission has done, the proceedings are running, your lordship, it is urgent for our reply, and we have filed the reply. They may fix another date. And every date they are sending a notice, register posted. That is.
Yes, madam. Now it is pending before competent authority. You should relax for a while also.
Yes, my lordship made this.
Mark the presence. In this petition, petitioner who is a medical practitioner 21/6. State medical, huh? The full stop.
Sessions on 200.
26.
May it please, I am for petition.
My lords,
Dairy farm, madam.
my lords, without,
This is also human rights.
yes, my lords, there is it's a pollution, my lords.
So then
Pollution complaint has
we
been
don't
filed.
know, madam, what power do you have under the act to enforce you can't pass an order. You can only make a recommendation to the government. Right? Your recommendations, I mean, they in ordinary courts are binding on the government. How issue pertaining to adjudication is being taken up? If neighbor has a complaint that cow shed is being run illegally, no person other than you in the state of Telangana.
Yes, my lords, your lordship may,
So supposing council, yes,
lordship may decide in terms of section 12, my lords.
section. Yes. Mark the presence. 26. In this writ petition, Yes.
It's also erased under the Human Rights Commission. It's also erased under the Human Rights Commission order.
So then.
Page 24.
Ah.
Directing the authorities, my lord,
Milots, on submission, Milots. In this matter, Human Rights Commission is not made party, Milots. Even I don't have papers, Milots. I obtained order copy from the official website. Milots, the Human Rights Commission is not a party.
Yes, Mr. Complete.
my lord, yes.
Learning government.
Serve copy, Milots.
GP for revenue. First, he will implement, then serve a copy. Praise for how much time?
2 weeks, man.
2 weeks time to enable. List after 2 weeks.
Electrical elections. It's also your election they have made as a HRC in the
30. Yes. So have you filed an application? Oh, sanitary spirit. What is the complaint against you?
complaint made by the unofficial respondent to your lordships. They have
They've been
arranged a
served, right? Madam, these orders we are passing, they have been served, we believe, all these cases. Service is complete, no? Then we may not file a review later. No, I'm saying that.
That's which has to be done.
But that maybe you say that I was a necessary part.
Proof is there.
Rajini,
Sir.
all cases checked, madam, where we have dictated. Yes, madam. What do you say? This case also you are there?
Milots, I don't have papers, Milots. Even I don't know that this matter is also relating to HRC, Milots.
we have served. We have served Solam back.
See that somebody, respondent number 3 has made a complaint against the petitioner who is a sanitary inspector. And the complaint is.
Milots, earlier the division bench has ordered for producing of the HRC record, Milots. Milots, I'm submitting the HRC records, Milots, in this matter. Your Lordship may.
No, the complaint made by respondent number 12 within the purview of section 12, madam, by now you understand the law. Is it so or not so?
Yes, Milots.
We will not record your concession, but is it so?
Due to threats.
Something marriage bureau, etc.
Due to threats of the petitioner, Milots, she's died of heart attack, Milots.
No. Marriage bureau, she was entitled to some brokerage which was not paid to her. So then commission can recover the brokerage for him. You know it, right? Yes. With consent, everything you write with consent of
File memo also, your lordship,
Please see your memo.
69169.
Please see your memo and tell us whether it is served or not.
Delete this memo.
Sorry. Yes. Insufficient order, return your lordship.
Sir, what is your memo? Please read it.
Yes,
Now
yes.
you read your memo.
Sorry, your lordship.
You think we don't check all these things? You try to mislead the court.
No, sir. The mistake it was.
What mistake?
My office is, I am apologist, your lordship.
Is it not your duty
Yes,
to tell that, sir, respond number 3 has not been served? I have dictated the order.
Sorry, I am apologist.
No, and don't mislead, Mr. We, otherwise
I
henceforth, I mean, you people are suggesting
Yes.
that don't rely on us.
I never committed.
No, I was, we were all, both of us have practiced on that side and none of us has made factually incorrect submission like. So we tend to rely on you, that what you say is
Yes,
correct. You are giving a memo saying that served, which, and this thing shows that the service is
Yes.
because inefficient, sufficient address. Not fair to the court, Mr.
Sorry.
You are being let off with a warning.
Yes, sir. I will, I am apologist.
We will remember you. Person with a pink pen in his this thing.
I am sorry.
Will not forget you. Not fair, Mr. For a case.
Yes.
Unfair.
Not such intention, your lordship.
No, nobody has the intention.
Mistake
I mean,
made by
he
our.
can also say that I stabbed the person without intention of killing him, but I don't know he died. That is the standard defense. Be more cautious.
Yes.
Take this opportunity to pull up your office people and tell them that you were
Definitely.
put to an embarrassment in court 1 today.
Definitely. I am sorry, your lordship.
Delete that. Mr. Office report indicates. You keep the draft order in that file only. Now, right, don't type. Again, I will have to do this thing, dictate, right? So we will. So we have perused the record, though the service report filed on behalf of the petitioner, though in the memo for proof of service filed on behalf of the petitioner, it is served, not served.
Just, not some, you want to understand?
No.
No notice is ordered in this time, you want to understand. Just now I've seen, in this notice is not ordered is what my affiliation.
Madam,
This is also against the human rights commission, not.
civil dispute.
Pardon?
Civil dispute has been entertained.
And yes, it has been entertained, notices are also issued now.
What is the dispute about which this thing?
And it is in respect of a particular property covered by municipal number 2-45-33/10. Two civil suits are pending. An FIR is there.
Learned counsel for the petitioner submits. Heard on the question of admission. Learned counsel for the petitioner. as counsel for 1 and 2. This would stay in this case.
This matter, I filed additional counter in this matter.
Today,
On 8th, my lord. On 8th August.
you are petitioner.
I'm for petitioner, my lord. I filed additional counter on.
Yes.
How can you file counter?
Counter.
Counter is filed by the respondent.
Additional affidavit I filed. And along with additional
We
document.
have filed counter, my lord. 3 things are complete, my lord.
Counter they have filed today only, my lord. This, I
Who has
just.
filed today only? Who has filed today only, Mr.?
R1 filed counter.
Today?
Yes.
Today, my lord, in the lead case, we have filed counter long ago, my lord. 2 months ago, we have filed, my lord. This is a batch of petitions, my lord.
Adoption memo, right?
Yes,
Adoption memo.
yes.
So issue is, Mr., not like this. How can government teachers whose wives are working in, not working in government schools, etc., can be pushed below, down the seniority list? You forget about not laying rules and 309, nothing. Mr. Prabhakar has not properly argued the matter. That's the impression we get from the order sheet, right? His case is better. It is, what is the rational basis of discriminating the people who are your employees? How can, like, you say that, no, you must marry a teacher who is posted in government school, then only transfer. Basically, yes, office of create, I can have been like I'm sure that they will say, oh, I didn't. Teacher whose wife is also working as an employee with state central government. Not a teacher who is working with state central government. But central government is told that make them eligible to post at the government. So these additional points, 10 points are giving are being given to those teachers whose wives are working, spouses are working, to enable them to be together, right? That is the object.
Yes, that is the object, the rational being. That's so simple.
I have filed additional, one more GO, my lord. That's GO number.
You want an adjournment, right?
180. GO number.
Petition is, yes, mark the presence. You are seeking adjournment.
You had argued one matter where I had passed an interim order. With regard to the central government, there is a issued under presidential order 1997, if I recollect correctly, wherein the, in order to keep the spouses together, a benefit was sought to be extended. So that was not there in 2018 presidential order. And when GO 317 was issued, so I looked into that and said it should be provided. That was the interim order passed by it.
It's for the central government.
In this.
That's so for the state government employees concerns, the GOs are elected. And by virtue of this order, my lord.
Yes.
Not by virtue of this order, my lord.
Everybody.
Granted, my lord.
No.
2,000 people have applied for transfer. The list has been prepared in the month of February. It is supposed to be completed by end of the February. Milord, on that day, Milord, this order has been passed, Milord, to the extent of awarding 10 points to the spouse that is concerned. We are not concerned.
No, but the council standing, he is seeking adjournment repeatedly. He is the only person who said, I have filed counter, I have filed.
Other person comes and says.
My lord, I filed in additional documents.
That has nothing to do for this application of this case.
Please wait, sir.
It's only tactics to attend the matter.
Same thing.
For 4 months back, the order is passed, my lord. But the entire administration.
So get ready, 1:30, you have an hour's break, we will decide it. No, that's you always have a respect, you need not say every time, please, that we understand, yes.
Respondent government has produced the rules before the legislature.
That we have noted down, Mr. You have said that it's Article 309 power cannot be invoked if there is a power under act and it has not been published. That all we have seen in the order. The real issue is
Just now they
challenge.
memo winner.
Why did you serve a memo just?
Just now only, 12:30 they served memo on us.
That is the laying down. Rules are laid down in the assembly.
No, but why do you serve when the case is about to be called?
All we have served 2-3 days back, my lord. We could find Prabhakar today.
Prabhakar online on that day, otherwise we will not. Last occasion is online.
On one pretext or other. they are
You
getting-
tell us, I mean, it has to be heard, right? When give a synopsis, Mr. This is not the way. If you want,
people are being
Mr.
arrested.
Yes, we will.
Additional Advocate General, if
We
you
have
want
page.
hearing, give a 2-page synopsis. I mean, we cannot start noting down
We have-
when they were born, what happened,
We
when
have
they
page.
got married.
We
We
have
will
page.
argue like this one.
We have prepared the synopsis.
So then, ready?
Ready.
So, you are also ready, no?
The agency is involved, about 60,000 people are haunting me.
You are for the petitioner.
I am for the respondent. I file a
There is a stay, right? There is a stay against you.
Says we Lord. About only for sake of 4-5 people, 64 people are suffering.
There is no constitutional validity to this.
Let it be withdrawn.
23-8.
Lord, by the time we learn that again academic year, in the middle of the academic year, election will come.
23/8, 1 week next Wednesday.
Oblige, my lord.
Since when stay is operating against you?
I may not have.
No, tell us.
Till
Since,
February it is operating.
that's,
6
what
months.
did you do?
Will I- within-
I have, we have only spent, I have only spent, this bench has spent 3 weeks only here. What were you doing prior to that?
Same thing we learned by.
Within 1 month, we file
Seeking
counter.
adjournment. Mr. Prabhakar, don't seek adjournment.
Yes, I won't see it.
Another advocate comes.
I am ready to ask
Wait,
them.
respect.
Said only.
On that day, another advocate comes and seeks.
No, we will remember.
No. In this petition, the petitioner has, petitioners who are second. So you will do it.
Consequential promotions also have been stalled. My lord. By virtue
That's
of
why 23rd.
transfer and promotion, both.
Yeah. 37 madam. Plus 37 to 37 to 40. 37 to 41. So we have already passed an order, detailed order. Yes, Mr.
We'll file counter without lodgement grant 10 days time.
Oh, Mr. Mr. Prabhakar Rao, learned counsel for university, praise for and is granted. How much time? 2 weeks?
Yes, sir.
2 weeks time to enable him to file counter. Interim order granted on the later occasion shall continue. This is 37 to 41. What?
Waiting for respondents.
Oh, the sensitive issue. Mr.
Appearing for respondent number 5 in 40.
No, we don't get it. 5 means what? You should
GHMC, Milord. We filed our counter and we have taken adequate steps, Milord, along with the detailed report we will file.
What are you to file? I mean, that you should be able to come up that in past so many days or months, no case of illegal transportation of cow has been reported. Saying that the guidelines always exist, right? The law is already there. But despite that, people are committing offences and they are right. Right?
We have catch.
So simply saying that this provision is made, that committee is there. We need to ascertain this thing, the system, whether it is functional or not.
It's actively functioning, Milord, and we also handed over several cows to the Goshala, and every year.
You give us what is the status of how many this thing?
We have stated in our counter affidavit also, Milord.
Where is that?
In Sumoto Bill number 5 of 2023, Milord.
No. No.
Respondent 3 counter.
In the first matter, only respondent number 7 has filed a counter. He appears for R5. Mister, we are taking Bill 74 of 22. There is no counter.
Counter is filed.
When?
It's additional advocate general on behalf of GHMC, they filed counter.
Mister, you have GHMC has filed saying that there is a act, cruelty of animal transportation rule and act is there, but we are
page number
on the
5, number 6, Milord.
No.
Page number 5, para number 6.
So this is what on a particular festival only you do it. You have to do it all round.
Yes, all round, Milord, we are.
When? This was filed July, 18 July. Where is the action taken? Where these 750 animals have been handed over?
To the Goshala. To the respective Goshalas.
This is 2021 only.
Yes.
What about?
Milord, in the next matter,
additional government advocate. You are what?
I am standing counsel for GHMC.
Learned standing counsel for GHMC has invited there. filed within a period of 2 weeks. What about 43?
But same, similar matter, my lord.
Same order, 43.
He had filed a report taking the steps taken in their 2015. But his bill is not by us 2015.
We'll take it up. The issue is common, both the cases. It will come after 2 weeks.
Yes.
Like,
And we have this.
we'll take it up.
House and all.
Mister, you said cows stroke animals. All particulars, like animals also, right? That will include the dog also. Correct?
Right.
Yes, yes.
This, with regard to ORS, safety.
What? ORS, yes.
44.
Array, Mr. Madam, 2nd August 23. Learned additional government advocate submits.
But I request not 3 weeks time.
Learned whatever government. All right, Mr. G. Praveen Kumar, learned DSCI press warrant is granted 3 weeks time to enable him to call counter. What's your, yes, madam? So and so appear for which respondent?
I appear for respondent number
5, 6. 5 and 6. Submits that the counter shall be filed during the course of the day. You, Mr.
I appear for respondent number 2, the FSACI, I also filed my response in 2 weeks.
So two, this 1 and 2 pray for and are granted 2 weeks time to enable them to file counter. 3 weeks, right?
3 weeks.
And then she record her statement.
Right.
List after 3 weeks.
I'm
List
so grateful.
immediately after 3 weeks. Yes.
In this matter, my lord, I appear for the forest department, my lord, respondent number 3 and 8, my lord, I request, my lord, the 2 weeks time for filing counter, my lord. I appear for 2, 4, 5, 6, 7, counter filed today, my lord.
3 weeks time already granted on 24/7.
My apologies, my lord, the
3 weeks time, yes, write down. 3 weeks time was granted to, just a minute. 3 weeks time was granted to government leader
forest
on 24/7/2023.
revenue file.
Just wait. Pursuant to order dated 24/7/2023, and the matter was directed to be listed today. Paragraph GP for revenue states that in pursuance of the aforesaid order, revenue department is already filed counter on
today, my lord, USR number 77138.
today, so and so. However, GP for forest
Request 2 weeks time, my lord. File the counter.
is granted 2 weeks further time to file counter, failing which, nothing.
Will not give the
Don't give a chance to forest.
oblige.
Don't write failing which, no. 2 weeks further time. IPS officer you have implemented.
Yes, my lords. It is numbered as IA 1 of 2023. It is numbered today only, my lords. It is numbered today only, IA 1 of 2023.
Let the matter be listed for consideration of IA number
1 of 2023.
1 of 23 on Saturday, 19th August 23.
Registry to put up IA 1 of
Registry to put up.
No, get your.
No, there is no notice is issued, Mr. As yet.
Send the matter to
No
Saturday.
notice.
Get your instructions, whatever.
Whatever, they have to yet to be heard on admission. All. Acha, call you since you have already called. Councillor there? Yes.
This matters to heard finally, that was the understanding. Learned advocate general is to argue.
Yes. Finally today.
Yes. Lord, I had argued for IA2 1 week back. Lord, it was said that matter itself can be heard.
Just 1 minute. This paper book you give one part. Just I want to see what is the matter. Yes, we have said so. Order sheet says so.
Instead of IA, you also said you would hear.
Shall we take it up at the end of motion hearing, Advocate General? So others need not wait.
Very good.
We let the think around 3:30 or whatever, quarter to 4. So tentatively, it can come earlier also.
Yeah.
So these are all 47 to 50.
47 and 48.
47, 40. What about 49?
Lord, in 49 also I appear, it's coming for my lord admission. That was can.
49. All right. So this side is 48 and 14, 47, 48 are at the end of motion hearing cases, and we start with 49 after the break.
Very.
They have not decided.
May I please your lordship, matter pertains to medical admission, my lord. The petitioner, I have filed the merit list issued by the university, my lord, which is at page 13. The petitioner finds place at rank 850, my lord. But the petitioner is wrongly placed as non-local, whereas she is a resident of Hyderabad, my lord, and she has.
That subject matter is covered by full bench judgment, lordships, against her. Lord, may I pass on?
Which judgment? No, we are dealing, no, various persons claiming like they have
My lord.
completed 10 years, Mr. Rao. They have completed 10 years in Hyderabad,
also
2 years in Chennai.
That is also considered. In that case, my lord, the candidate studied, my lord, +2 in Gujarat. My lord, page,
Oh,
para
you,
6, my lord,
you
is the
came
facts.
to know about it later. Huh? This full bench.
Full bench judgment and also, my lord, the.
Yeah, but you accept notice like we
I will
can't
accept-
decide it in motion hearing like this.
Lord,
We have not read the file, lunch motion, obviously, we don't know.
my lord, connected matters are coming on, my lord, 18. It may be posted on 18.
My lord, I make
So what
one.
are you doing in the meanwhile between 14th and today and 18th?
My lord, the 17th, my lord, the list of cases are listed, my lord, that is questioning GOMS number 72.
No, that's correct.
But
We are asking,
they have
we are not doing anything till then.
No.
No
When
adverse
we
order.
issue the list, my lord.
They are not
If they
releasing,
issue
my
the
lord.
list, my
They
lord.
are not releasing, my lord, the web options.
My lord.
Lords may not
I-
record my statement.
May not fall.
Lords may not record my statement.
Statement to the court, we'll put it on record that no web options will be released before 17.
No, statement of counsel according to you is not sufficient, right?
My lord, this is a very peculiar case, my lord.
No, madam, we
Yes.
can't say that you are at number 1 in the merit list and first admission should be given to you at this stage.
My lord, she is at.
You are disputing the rank assigned to her. And
I'm not disputing the rank, my lord.
that's what you are saying, that I'm much higher. They have shown me 850 number in the list.
No, my lord. I stand corrected, my lord. I have not made that.
So this thing, you are not being treated as local person.
Yes, my lord. Only for the reason, my lord, for 2 years in her 12th grade certificate, Kota, Rajasthan.
You know, Mr. Rao,
Not,
what sort of an interim order we have passed in those petitions?
In those cases, my lordship passed an order basing on another division bench of the honorable court. my lord.
Where SLP is pending.
Not SLP pending, not in this case.
have placed.
My lord, subsequent division bench of the honorable.
Yes.
My lord, subsequent division bench, my lord, subsequent division.
We just want to understand the urgency. It needs consideration. You will agree, Mr. Rao, that this issue needs consideration, right? We need to examine whether full bench covered by it or not. What is it? But we are at the same time, we have granted interim order in some cases. Now, madam, in those cases, interim order was granted because they approached us saying that last date for indicating web options is 6th of August 23. Now we are 14th of August.
My lord, the petitioner has exercised the options. I only make one submission, my lord. The petitioner's case is, my lord.
Please understand, similar matters are coming up. Mr. Rao knows better. On 17th August, we will grant him time to breathe and to go through your petition.
My lord,
And
till such.
so we are only ascertaining at this point of time what relief you want and what can be granted to you.
My lord, in similar situation.
She should be admitted to the course, right?
Yes.
Huh?
My lord, but I'll make my submission, my lord. She is at 850 rank, my lord. She will get a seat, but she will not get, if she is considered as non-local, my lord, she will not get seat in government medical college, my lord. And your lordship may see the residency certificate is. Let
Madam,
me
how
state
can-
facts, my lord. The petitioner is studying in Hyderabad from 2010, my lord. Her father is a scientist in ICAR.
Arey, Mr. Rao, you must tell us, right? You must tell us, I mean, we have to, these interim orders which have passed, we have passed, they are binding on us. We can't take a different view.
That's true, my lord. Now the latest development is, my lord, I could able to place, my lord, the full bench judgment of this honorable court and another division bench. Holding, my lord, that the persons who are studied outside the
Mr. Please appreciate that other matters, similar issues involved. We cannot not hear them and decide today in your favor by relying on full bench. It needs consideration. You have said that we want to fix it for 17-8 when other matters have come up. But the question is, Mr. Rao, what interim relief? She is unable to explain. You tell us what interim relief has to be granted to her. She wants admission in the course. That can't be done. Why?
The reason is, let's me kindly see.
When was the counseling held?
The counseling, the web counseling
First round of counseling when it was held?
is over, but the allotments are not made owing to the reason similar matters are coming on 17. With regard to JMS on 72, this batch is coming on 18th lordships.
18th. So, madam, he is making a statement in view of similar matters. They are not finalizing the list.
I understand that, my lord.
First round of counseling, madam, please one more sentence, then you argue whatever you want. That first round of counseling is over. Second round of counseling is yet to be notified.
It is not that, my lord. First counseling, they are going to release the list of and allotting the seats, my lord. That is not done, my lord. That is not done.
Just now he said, Mr. Rao said that because the similar issues are pending adjudication in other writ petitions, he will not do so. Probably, did you not hear him saying that?
I understood, my lord.
Mr.
Mine
GP said no. He said like that.
I get that, my lord. My submission is, my
You
lord.
go through the full bench. It's very easy for us to dismiss the petition relying on full bench.
That, my lord, I am entitled for a similar interim order. For one reason, my lord, I stand in still better footing, my lord. The petitioner never left Hyderabad. She studied from, that is a case where the petitioner has studied part of her education in other place. She has studied entirely in Hyderabad. Only one thing is, my lord, before COVID, the father of the petitioner anticipating his transfer, he registered in a school in Kota. She pursued all her education, even the exams she has written, my lord. She has written the board exams from Hyderabad Center. She has written her 10th exams from BPS school from 1st to 10th. Your lordship may kindly see, my lord. For a moment, my lord, for my satisfaction, your lordship may kindly see.
Madam, everything, we will hear you till 4:45, no problem. But the thing is, we told you, probably you did not get it, that this issue, we told Mr. Rao, requires consideration. Similar matters are coming up on 17th. In the meanwhile, what is the interim relief to be granted? What will happen? First round of counseling is, yes, first round of counseling is over, madam. You have come today. First round of counseling, when over, Mr.
August 6th, my lord.
6th August.
Gave a representation, my lord. They have not considered. That is pending.
You had this thing, you
Wednesday we have filed.
you relied on them for 8 days.
My lord,
waited.
Because
What
produced
can be done?
certificates, my lord. Till now they have not done anything. It is not that the counseling is over. They are going to allot the seats. Similar.
Madam, conclude what you want to say. We are not deciding this writ petition on merits right away.
I'm not.
He has to give, we have to give him time to respond. Similar matters are coming up on 17-8. So your assertion, we have understood that I am a local candidate. They are not treating me as local candidate. Even though I was registered in Kota, I have written examination in Telugu and has stayed in Hyderabad. So understood. What interim relief?
Similar.
First round of counseling, again, third time we are telling you, first round of counseling is over. They are not declaring the result of first round of counseling because the issue involved is pending in a batch of writ petitions, which is coming up for 17th. He said so. We cannot, by way of an interim director order, direct that special round of counseling be held for you today and you be admitted as #1 candidate in local category. We can't do it.
My lord, I am seeking a similar order which is at page 79, my lord.
You are entitled to parity undoubtedly, but those students had come early before 6th of August. You are coming now.
My lord, the list is not yet finalized, given by them, my lord.
No, in fact, he's saying, madam, he's saying he will not finalize till 17. till the matter is taken up by this court, what is
Along with
problem
the
I am
other
arguing?
similarly situated
At least
persons,
I am
I may
unable
be
to
given
understand
the
what is-
benefit of the
when
interim
there is
order, my
an
lord.
undertaking, when there is an undertaking that they are not going to release the list in respect of the candidates who are selected in the first round of counseling, what is your problem? That is what we are unable to understand. We are stopping entire process of declaring of the candidates till 17th or 18th. 18th.
I will. But in similar case, there was an interim order. I was only
But see that the time gap, you have waited 8 days. We are saying wait for 4 more days, and in the meantime,
let them not finalize. Let them not issue.
In fact, that is what we are undertaking is, this recording is undertaking,
Yes.
that he is not going to finalize and declare the result.
Yes.
So that on 18th we can consider.
Yes.
Are the present learned senior counsel for the learned counsel for the petitioner. Madam, keep full bench. He submits. He has also shall not declare. However, it is submitted that the issue involved in this writ petition has been answered by a full bench of this court in so and so versus so and so. Sure. Is
NLD organization will not even have the statement that he was fighting. He has passed 10 place to answer in regular.
Oh, you have changed your idea?
No, my lordship. Actually, this petitioner, he is having an opportunity to get himself enrolled in other state bar council.
Yes.
He instructed me to withdraw.
This the better way, smarter way of doing. You tell all those people they should follow you and get registered in other states. And
This is the fourth writ petition I am withdrawing, my lordship.
oh, learned counsel for seeks leave of this court to withdraw the writ petition is permitted to do so. Accordingly, writ petition is dismissed as withdrawn. Yes.
Obliged.
Correct.
May I please your lordship? My lord,
Same order?
no, the petition is not even studied, my lord, in the state of Andhra Pradesh.
My lord,
Telangana.
my lord,
Same order, right? 18-8.
18.
Ah,
my lord, the
It's a-
petitioner's father is an army
I am
officer.
unable to see them.
Petitioner's father is an army officer and father was a domicile of state of Telangana.
Interim order. Madam, we are entertaining the petition. He is there to accept notice. What interim order? First round of counseling is over. Second round of counseling yet to be notified. He has already said we will not declare the result in just 2 minutes ago. We have passed an order which you have heard. What interim order in your case?
My lord, only one submission, my lord. Petitioner has already
We'll
submitted.
hear you on merits.
No, only one submission, my lord. Only one.
What stay you want?
Pardon me.
What interim order you want? That's please tell us.
To consider the exhibit P6, my lord. That's all. Because already she has uploaded, she has already uploaded the residence certificate of the petitioner, my lord, of the father of the petitioner, my lord. Exhibit
The only
P6 is
relief in the
issued by.
petition. This is the only relief. We will dispose it all.
Lord, this particular exhibit P6 is given by the armed forces, my lord. Because already this was uploaded in the website, my lord. And take,
You will be considered under CAP quota or not?
yes, my lord, I am considered under the CAP quota, my lord. Already the CAP quota was considered, my lord, even on page number,
So, madam, the interim prayer is to permit you to participate in the counseling.
yes, my lord.
First round of counseling is over. Second round of counseling yet to be notified. As and when it is notified, please come to us. Read your prayer, page 20.
Yes, my lord, I understood.
Please read.
No, I know about it.
Please read.
Yes, my lord.
For our satisfaction.
May we please to direct second and third respondents to permit the petitioner to participate in the NEET counseling.
Is it being held today, tomorrow? What is the date of counseling? When was first counseling over, Mr.?
August, 6th August. 6th August.
6th, one day only.
No, 4th to 6th.
4 to 6, minute. 4 to 6. Sorry.
My lord, being an army officer, he was in Jammu and Kashmir, my lord.
No, madam. Please appreciate that we are not dismissing your petition.
Yes, my lord.
He is entitled to respond, right? He is
Yes, ma'am.
required to go through Mr. Rao and to contest your prayer.
Yes,
We
ma'am.
are only adjourning it to 18th of August.
Okay.
And then, that's why till then, what interim order? We are asking no interim order. Nothing can be granted. Mark the presence heard. So and so on the question of admission notice. We finish with those who are waiting. What? Yes, we.
But I'm sorry, my
Sorry.
Balance. One. Then.
But this thing, survey thing without notice. Ah, yes.
But my apologies, my morning was not present. But my
fine.
apologies. Well,
Yes.
They said that you are in possession of some land.
no, I'm in position. The issue is that, my lord, your lordship may come to the.
No. Why we wanted your colleague must have
Yes,
told
my
you
colleague.
that what they said is that the survey has nothing to do with the land in your office.
No, my lord, it's being surveyed. That's what is my precise case also.
Fine.
Your lordship may take the impugned order, my lord, for a moment.
Fine. All.
Your lordship may take the impugned order, my lord.
Now, which you are claiming which this thing title
We are,
which
we are both in same survey number. We are the first cousins, but both of us are first cousins. And my lord, we are in same survey number. Both of us are claiming equal and extent of land.
no, which survey number?
My lord, survey number 144, my lord.
No, it is subdivided into so many things. They have produced
Now,
the record.
now by virtue of this impugned orders, it's been subdivided.
No. The notice itself is for survey number something like that.
That's where again the fraud is played. I'll just give me a minute, my lord. Your lordship may come to the FNL counter, page number 202.
No, you tell us which survey number you are in possession and claim title.
My lord, I am in possession of survey number 144, my lord.
How many acres?
My lord, survey number 144 by A3 and 144 by B2.
A3?
A3, capital A3 and 144 by B2. My lord, the issue is, my lord,
So, notice is also sent.
Yeah, yes, Mr.
My lord,
We have seen the record. There is no scope for arguing the matter again. We have heard you at great length and recorded everything.
Yes, perhaps.
And we have seen the record. Perhaps it's the time when he should argue.
Only one paragraph from the impugned order, my lord, and rather two paragraphs, then I leave the lordship. My lord, the lordship may come to para 50.
You can submit by way of a rejoinder after he has argued. We don't know.
No, before my friend has a benefit of answering to this also.
Yes.
Page 23, para 15.
Page 23.
Para 15, part of the impugned order, my lord. Last 5 lines in that page, my lord. But in the instant case, though it appears that there is no notice issued, the learned judge gives a finding, no notice is issued to the petitioners before conducting the impugned survey, as already noted above, the person in occupation of land being claimed by the petitioner was put on notice. Even otherwise, such a notice was in fact issued to the person in occupation. Now, my lordship, the person in occupation of said land or not is also a matter which can be better looked by the appellate court. 16. Even otherwise, assuming that no notice is served on the petitioners while conducting survey, resulting in submission of the impugned report, as already noted in above, there is no prejudice caused to the petitioner here, and therefore the court does not deem it fit to interfere so and so. Now, my lord, your lordship has noticed that it has been given notice to the person in occupation, one Putta Ravi. I mean, survey was conducted on 1/7. Notice was on 7. Your lordship may now come back to page 22, my lord. Last sentence of para 12, just above para 13. The person to whom the notice is supposed to have given has purchased the property on 7/9/2015, a part of it. That is much after the survey is conducted. So the question of notice.
Where we are, page 22.
Well, just above para 13. The person himself has purchased the property on 7/9/2015. The question of notice being issued to the person in office.
This person is the respondent here for whom he...
No, he is supposed to be the person who has received the notice. That person came into picture only on 7/9/2015. So therefore, the question of notice would not be correct.
We have ascertained that fact from the record which has been produced.
Anything I have given the
Yes. Mr. Yes, please. So first submission is alternative remedy of appeal before whom?
Before the RDO. As per the circular. And second submission, he has filed a suit. And page 13 of my counter along with the papers.
Filed
Very same.
for
Suit for cancellation of this my gift deeds in my favor and also for recovery of position.
So.
Your Lordship, I just kindly,
No.
as far the possession extent is concerned, Your Lordship, I kindly copy his writ petition affidavit, correct page 32.
No. So I mean that no notice is necessary because he has filed the suit.
I'll come to that. Notice is necessary. Notice has been served according to me, my lord.
We have the record. With us.
That I will. One thing, let me.
Mr. We must indicate to you that this thing before you argue, from the record we have found out that notices issued to these appellants have been pasted in the office of Gram Panchayat. This is what the record says. There is no personal service.
Gram Panchayat, my lord, on the house also affixed, and also it is served on the one Ravi.
Subsequently, his signature to Ravi.
Yes.
Minute, Your Lordship, just
That also we have seen from the record to whom it has been served.
That Ravi is concerned that he was in position prior to the agreement of sale.
He has acquired title subsequent to date of
registration took place subsequently, but he was in position. But if subsequently comes without the question of without surveyor, without referring to that name would not arise. He was in position prior to that on the basis of the agreement.
No, these appellants claim title through this Mr. This
same petitioners. Petitioner. Petitioners, whether they claim the title.
No, what do you mean to say? What's the petitioner's name, appellant's name?
My lord, G. Madhukar Reddy, my lord, and others, children of Guda Ramna Reddy. He died, my lord. By the time the survey, he died. Now the contention is because my father.
From Teja Ravi it was sent. Which?
I mean, Putta Ravi. He is a purchaser from these people. Purchaser from these people who was on the basis of the agreement and he was a cultivator. Thereby, my lord, the surveyor has served on the cultivator and also affixed at the Gram Panchayat and also informed them according to the report. He has informed the legal aids.
So Mr. 1 minute. So Mr. P. Ravi purchased the land from petitioners when? When?
I'll just give the date.
Land from respondents. No, but we are talking about appellants, whether notice has been served to them.
But he's not a party yet.
Who?
Putta Ravi is not a party.
No.
This Ravi purchased from whom? Your client or Mr.
I claimed a part of the land. On 7/9/2015.
7/9. That's
7/9/2015.
A part of it, not entirely.
after this
Survey.
Yes. But according to that, he was the cultivator. He was cultivating. Under the agreement, he was there.
All this we decide in a writ appeal, right, Mr. Whether he was cultivating possession, this all right.
Lanajan found that service affected not only on that.
That's why we have called for the record. There is no order, there is no record showing that it has been served to them.
To his concern, his father died. His father he is not got recorded his name. Therefore, as per the old record,
No, you will agree, senior counsel, that survey does not confer any title on you, even if it is held to be in your favor. So we don't understand why you are defending it. All we are trying to say is that give notice to parties and then conduct a fresh survey. And even if for that survey, even if your name is entered in the revenue record, then also you won't get a title so long as suit is pending.
This man is filing suit after suit. These litigations are going on. Earlier, he has filed a suit against his sister, and again now suit. Again, there is another petition also filed in the village which was disposed of in respect to other survey numbers. That is the problem. He will not allow the partition which has already taken place to take effect. That is the difficulty. The repeated litigations are going on between the brothers. Otherwise, there is no question of.
They are brothers, right? So why don't you avail of this mediation thing?
First cousins, my lord.
mediation.
He will not, he will not compromise.
I will be so confident how.
He has filed against.
How you are so confident he will not come? You are a counsel, right?
That's what they said. I discussed with them.
My lord, I'm sorry.
Your Worship, kindly see, my title is concerned, he has a position.
No, we are not giving any finding on anybody's title. Saying the revenue officer to carry out survey after giving notice to you and the appellants does not amount to recording a finding in this writ appeal that he is the owner and you are not the owner.
Right. Well, my only submission is
We will clarify also that we have not expressed any opinion who owns the property.
Yes.
That is to be decided with this court. Supreme Court has said Mr. 226 title, etc. cannot be decided. You are aware. This is survey.
not decided. That is only said. There is an appeal and survey notice.
That's what we have to see. Whether he should be relegated to remedy of appeal, we will shortly answer as soon as you conclude the submission.
I hear you, Lordship.
You know.
Give me a conclusion.
No. You tell us subject to what you say.
Also possible. My endeavor is only saying that they have taken all efforts. Two stories have been issued. Page 212, 213, 214.
You tell us a date on which you will remain present, both of you.
Any date fixed?
He will, so that we don't want any notice. Then we don't want that he will say I was not served.
No, but any date fixed?
You tell both of you.
Any date.
No. You tell us it should come from jointly from you and time.
But the only thing
We will direct
government,
him to.
government has to say when is it?
No, government will do it. They are subject to our orders.
The first week of September.
Mr. Senior Counsel, first week of September.
So they have to take some steps and communicate all this.
He says suggesting first week of September. You
Date specific.
Date specific. Date specific.
which date?
What is the extent?
11 acres, 29 guntas.
Why is 11 acres, 30 guntas admitted by him?
No, total extent, because I am only looking at. the-
46.
Total 46. We have to give them 2 days minimum because the extent is 544. So we will have to give them 2 days. 9, 10, 10.
Second Thursday.
They will complete the survey.
Saturday.
3rd of September, Saturday, it's Saturday, 3rd of September.
Second is Saturday.
Second is Saturday. Fourth.
Second
September.
Second and third, so that if in
Yes,
case there is a spillover also, it can go.
Yes.
Next day, we will say that in case he is unable to complete on second, then he will continue on third, but conclude.
Yes.
Right? Yes. This mark everybody's presence. This. This was what case, madam? Paso? 20? Hmm. Hmm.
May I please, Lords? No, item 49, my lord, appeal file with leave, my lord, against the order of learned single judge. No, which is at page 20. Lord, the order operative portion, Lord, will find at page 24, paragraph 5.
Yes. What is it? I mean,
Lord, the order is passed, my lord, the instance of writ petitioner stating that the authorities are not registering because of a injunction granted in a particular order, I mean, CMA 118 of 2020. And the learned single judge, my lord, looking into this order, says that this is not in respect to
looking to register. That's the village. No. What we want to take the order is we have to work. This box. What this order was passed on 27/4. Is there an interim order in your favor in this appeal?
No, my lord. And there was a delay and, my lord, a leave, which lodges now, my lord, condoned it and leave is granted. So now I am, my lord, submitting on my lord, interim order.
No, so it has not been acted upon, this order?
No, that's what the learned council said last time, when the stay was to be argued, they said they are not going to press, my lord, for a sale.
Have been acted upon, my lord, because of the injunction granted in a different CRP, different CMA by this honorable court against the present writ petitioner.
Okay.
So like, unless that matters have been heard, I believe, by learned single judge and reserved for orders, until, my lord, that judgment comes out, I cannot sell anything, my lord, out of this order.
My lord, then
I can't take benefit of this.
I have only one submission. Let that be recorded. My writ appeal be
No, my lord, he himself stated so in the writ appeal. Those are the matters in which, my lord, his client is the party.
Third contingency. Third paragraph. Yes. Not in knowing properly. Let's see everything is on the copy which we used to.
Those orders, your lordship will see at page 391.
1 second.
I'm sorry.
I was guessed. Then Mr. Where there is a status till such kind already they can register. Which CRP?
My lord, kindly see at page 391. Page 391, my lord. To which, my lord, his client was the petitioner, my client was the respondent.
391.
Operative portion, my lord, at page 393. Or rather, my lord, kindly see at 391 itself.
390?
391 itself, my lord, last but one paragraph. 391. Upon the motion made by court by so and so, this court has directed that an interim injunction shall be issued to the respondent number 1, my lord, that is my client. Herein, their servants, agents, and representatives, and so, we restrained by an order of injunction from in any manner alienating, transferring, selling, encumbering,
So it can't be sold, right? You
I can't
agree?
be sold. I can't be sold.
If that is recorded, my lord, enough.
And?
It is a
No, my friend concedes that can be recorded. So there's no, I have no problem. And this is the subject matter is, my lord, 392, item 2. Is a property. Injunction granted in the warrant is at page 3.
So we can dispose of this appeal itself, right? Recording your submission that till judgment is pronounced in CRP 7 of 2019, you will not alienate.
And say me. Lord, I can't alienate by virtue of the court.
Yes.
I can't alienate.
My lord, yes. Unfortunately, relationship is that of a daughter and father. And in the order of learned single judge, they misrepresented by giving different order, which is at a different page. Right? Lordship, can you see? That is order. They show an order which is not relevant. and get an order. That is the
You want
reason
us
I had to file.
If you want to argue on merits, my lord, I can make my submissions. Lord,
I
my
was
lord,
saying-
as on today, I can't
Alright.
tell anything.
All right, yes, heard.
I'm
Heard
submitting.
on the question of admission, appeal is admitted for hearing. Notice is accepted by so and so. Learned senior counsel for respondent number. Yes, madam. You have written right exception. That read that. As falls within the exceptions as carved out. No, does not apply to number one. Whether you write now number one, whether the writ petition is filed for enforcement of fundamental rights. Number two, where there has been a violation of principles of statutory. Forty-two.
We filed vacate petitions to them. Yeah. Main relief was granted in interim order. Without effect, including affected parties, a blanket stay was obtained.
What blanket?
Installing the promotional process of all the posts without impeding us, granting national seniority and promotion.
There is some incomplete petition, right? Who has filed?
But my petition was ordered. I lost a petition.
You have been permitted to be impleted.
Yes.
I haven't seen it.
That is IA 1 mil.
What wicket is saying? Interim direction as split one. We would like to see what was it.
Entire main relief granted in interim orders. Entire main relief.
What is the petition? We have not read it. It's only for IA. Therefore, we are asking. Otherwise, we have gone through from everything. That's why we are dependent on you. Or you, then we will list it. Then some other day we will come and read it. Right? You send the file, madam. By we will read it. List on
Your Lordships,
19/8/23.
Your Lordships, we had also filed a writ petition wherein her ladyships had directed registry
Madam, 19th August, it's coming up.
flag our matter along with this, Your Lordships. We had similar grievance which we had
File an
challenged.
application if you want linking. Some other case you are not before us.
Her ladyships had tagged my matter with this, after seeking Your Lordship's assent. The order has been passed in this case.
Your case is not before this court, right?
It was before her ladyships. Her ladyships granted an order to seek Your Lordship's sent to tag my matter.
That was a
along with
very
this.
debatable issue which you are this thing. The expression, there was a debate that lordship has no gender. It's not like lord and lady. Everybody sits on this chair.
My apologies, Your Lord.
No, we are not seeking your apology. We are telling you that this was a considerable debate, and last I heard was that everybody is entitled to be addressed as lordship. Lord has no gender, right? After any orders, it has to, I have to pass an order.
Yes, Your Lordship.
This is not the way. Go and meet Registrar Judicial.
My apologies, Your Lordships.
No, we are not seeking, Mr. Madam, what will you do with your apologies? We are only,
I want
you are a
to
young
bring
person,
Lordship's
young
text.
person, therefore we are telling what you should do. Go with this order to Registrar
Certainly,
Judicial. He is not prepared to tell us the facts, we will have to read it. Therefore, we have listed it on 19.8.
Oblige, Your Lordship. Registered.
You did not say anything. We asked you what is the matter. You are looking at us. What can be done? Then you expect us to read it and not ask any questions to you, right?
May I please, ma'am? As against the order under appeal, my lords, another writ appeal 287 of 2019 was filed, which was dismissed on 22/1/2020.
287 of?
287 of 2019, my lords, which was dismissed on 22nd January 2020, as against which, my lords, an SLP was preferred, my lords, that is pending, my lords. In fact, in the last occasion also, my lords, that was the order passed by this court. SLP is still pending, my lords.
Find out what is has happened to this SLP.
That is still pending, my lords. Even I have
learned. Yes, madam. Heard on the question of admission. Condoned delay petition is what? How many days? Years. How many years rather? We shouldn't ask days, you know. One part. Heard on IA number so and so. One of 19 reasons assigned that order for forma thing.
140 days.
Delay condoned IA is allowed. Then heard on the question of admission. Appeal is admitted for hearing. Learned counsel for the petitioner submits that writ petition writ appeal involving similar issue, namely WA number 287/2019, was dismissed by a division bench of this court on 22/7/2020 against the aforesaid judgment of the division bench of this court. Especially petition namely SLP number 3978/2020 has been filed, which has been entertained by Honorable the Supreme Court, and in an interim order is granted.
No,
now you say in view of aforesaid submission, appeal is admitted for hearing.
But interim order is not granted, Messiah. It is in the stage of notices and all.
Until this itself says there is a stay until further.
I am obliged. I am obliged.
How you are saying? Therefore, appeal is admitted.
My lord, we have filed our counters. The matter relates to fixation of seniority. It has to be heard.
Executive engineer, deputy executive engineer and executive engineer.
Apart from the merits, my lord, I am raising an objection about coming to this court after a lapse of 8 years, for which there is no explanation in the entire affidavit. And this matter requires a hearing because it relates to fixation of seniority.
Learned counsel for
Respondents 3 and 4 state upon
3 and 4 submits that the issue relating to seniority of
in the cadre of deputy executive
seniority of assistant
Deputy Executive Engineer and Executive Engineer.
Deputy Executive Engineer and Executive Engineer
Please.
is involved in this case. It is further submitted that the petitioner who has superannuated has approached this court after an inordinate delay of 8 years.
Please.
And the matter requires consideration, keeping all contentions to be urged at the time, which may be urged at the time of hearing. A petition is admitted for hearing.
Great.
What? No, no. No, this demand notice. No, this surface. There is a stay, that's why he's sitting. Why don't you file this order is not applicable under section 18 of Surface Act? Huh? No, why you are not aware? Because there is an interim order operating. The moment, moment we vacate it, you will immediately become aware.
Last week is requested passing Krishna today.
Passing of an order. We will pass an order.
Next week.
When in this petition, the petitioner has said the validity of the order dated 15/6/2023, passed under section 7.
Lordship permission. This is a part in person. I'm representing Mr. Anil, Dr. Anil Kompalli. He is out of station, requested 1 week time.
My lord, sir, I'm
Because of personal
representing respond number 2 and 3, my lord. Despite the interim orders obtained, he did not attend for examination which was held on 22nd.
But he is out of station, he is applying.
No,
he was absent.
So requested a time.
No, what? I mean, you don't. Out of station means you should understand, right? What is he saying?
Yeah, understood, Milord.
What understood?
2 days time.
Then what this thing? What can you do? How can he challenge now this? He has lost this thing, his locus to challenge. Because despite opportunity being granted to appear in the written examination, which was held on 23/7,
Yes, 22nd and 23rd.
22nd, 23rd, he is not. You understand?
I'm not aware of the facts. He's out of station, requested me to take it for a time.
Don't
2 days time, Milord.
Don't do this thing
Milord,
in our court. The petitioner is a visually impaired candidate who has assailed the action of registrar of recruitment in not considering the candidature of petitioner for the post of district judge entry level. Paragraph. A bench of this court by an interim order dated, a division bench of this court by an interim order dated 4/7/2023 had permitted the petitioner to appear in the written examination for the post of district judge within bracket entry level held on 22nd July and 23rd July 2023. However, Mr.
Swaroop Urila.
who appear for whom?
Respond number 2 and 3.
Respond number 2 and 3 submits that the petitioner has not appeared in the said examination. Therefore, nothing survives for adjudication in this writ petition. learned counsel for the petitioner, however, prays for adjournment.
I'm not the counsel, my lord, I'm just.
We don't know, don't then appear.
My name is
Then if, supposing if we ask that how come you are appearing, then you will be in trouble, right? Without any authority, you are appearing in somebody else's case.
My colleague advocate is in that spot.
Prays for adjournment. We will have to say you are appearing in the case.
Yes.
We will have to say learned counsel for petitioner prays for adjournment to ascertain. You got it right. There was an interim order permitting to him to appear in district level entry, district judge entry level examination. He has not appeared. So therefore he cannot challenge the process of recruitment now. 19th August 23. Should I use? Okay, but I will see. Precaution.
In fact, my lord, on the
55 to 70.
FTL. FTL of the tanks. You have been. Yes.
It's to take up restriction.
Because
it says of FTIs.
So exhaustive directions were given on the last date of hearing. So have they this thing complied with it or didn't do anything? Perhaps you are referring to which order? 28/7/21. This is
13/6.
13/6.
My lords, we filed a report, my lord, on behalf of the respondent number 11 to 17, my lords. By state, my lords.
13/6/23.
Yes.
It's not that.
USR number, my lords. My lords, USR number 76583, my
What
lords.
have you done, madam?
We filed a report, my lord. Survey has been completed, my lord.
What today you have filed?
Yes, my lords.
See, all these youngsters are also learning the tricks. With that
apologies to lordship.
Matter is listed, then file it on that day and give SR number, so automatically it is adjourned. What do you get by polluting the tank and this thing, not fixing FTL, madam?
My lords, I'm apologies to lordship, my lord.
We have
even tell us about this matter.
Yes, Mr. We have already issued. No, Mr. Which case we have already issued directions and you didn't appear, your colleague appeared and we told him that file a report.
Another matter, not
It is bill
Which number?
196, my lords.
WP number?
Because last year, 196.
WP number
196
of
2023.
196 of 23?
Yes, my lords.
Bill.
No, not. That construction of some building alongside the lake, we said you construct in accordance with building.
Sorry, my lord, University building, that college building, we had passed with that order.
He has appeared, you know it, Mister. You have appeared.
Correct. No, but in that we said that please do the FTL, fix the boundaries of FTL for all the lakes under Kuda limit, HMDA limit. These lakes also get covered by that.
Yes, bro.
These lakes also
Alright.
get covered by
It
that.
is the number, Mister.
What is the PIN number?
196 of 2020, my lords. Bill number 196 of 2020, my lords.
196.
There are, see, this thing, we have already issued directions. He was appearing, he did not bring it to our notice. that there are exhaustive directions. So in that case also, it would be better if we hear it along with 196.
Your Lordships, one submission, Your Lordships, item 63 to 74 is different, Your Lordships. Item 63 to 74. This pertains to payment of compensation, Your Lordships, wherein on petitioner's land, the authorities are constructing compound wall. Your
Yes, petitions are admitted for hearing. List, you write item number 55 to 62. 55 to 60.
Lords. 196 bill pertains to floods, my lords, regarding flood reports. 28 of 2023 pertains to this one.
That's what we are asking, not flood victims.
28 of 2023.
PIL number 28 of 2023.
Regarding fixation of boundaries in buffer zone, my lords.
Huh? No, you should know at least the number, right? You have appeared in that case. What is the number?
28 of 2020.
WPPIL. 63 is what different means?
Yes, Your Lordship. 63 to 74, a set of writ petitions wherein the petitioners are the landowners, Your Lordships. On their lands, GHMC is constructing compound wall, Your Lordships, without payment of compensation. Construction.
Give, madam, 63 number. 60.
63.
In fact, the GHMC has filed counter, Your Lordships. I have to file reply. The other respondents have to file counter. Irrigation department. Irrigation department is filed.
Is there any interim order?
No, Your Lordship. In fact, this matter.
All matters, right? 63 to 74.
Yes, Your Lordship, 63 to 74.
Please write, madam. The grievance of the item 63 to 74. Grievance of the petitioners in this batch of writ petition is about construction being made by respondents, construction of compound wall being made by the respondents for protection of the lake on the land belonging to the petitioners. Learned counsel for the petitioners fairly submit that the lakes are required to be protected by constructing a boundary wall. However, the compound wall, the same should not be constructed on the land belonging to the petitioners without payment of compensation. Correct?
Yes, sir.
As the same is violative of constitutional right guaranteed to the petitioners under Article 300A of the Constitution of India. Those several councils are standing, none of them has opened their mouth. However, in the interest of justice, let counter, if any, on behalf of respondents be filed within a period of 4 weeks.
My lords, may I interfere? My
I've
lords?
already filed counter. But for R5, I've already filed counter. You filed counter, they will be there on record. Not filed, not filed.
You don't say that I have filed this thing. I want to file. Nobody is 1, 2, 3, 4, 5 council are standing looking at us.
Yeah, they were arguing about it, not in the midst of it, we cannot.
You should have said no.
He was arguing the matter.
Not arguing. He just told us that compound wall. You should have immediately said, I want to file a counter, or I have filed. Delete that portion. Let counter on behalf of the respondents who have not filed the counter so far be filed within a period of 4 weeks, failing which appropriate order shall be passed.
Pollution control board file counter.
Whoever is not filed, whoever wants to file, they can file.
If you have filed, relax.
My lord, insofar as item 75 is concerned, may I please? my lord?
75, it is being called. Please wait. It will be called. Please wait.
Apologies.
Ah. Oh, you are Mr. Deepak Mishra, right?
Yes, my lord, sir. I'm sorry.
Oh. Ah. Yes.
My lord, insofar as item 75 is concerned, my lord, in this matter also, this was tagged along to the badge because, my lord, the respondent corporation, my lord, under the guise of making compound wall to the FTL is encroaching upon the lands of the petitioners, my lord.
Same grievance, right?
Same grievance.
Of the petitioner, same.
we have already filed.
That same order fairly submits that the whatever tank or lakes have to be protected, but compound wall should not be constructed on the land belonging to the petitioner, as the same is violative of constitutional right under 300A.
Already filed counter saying that land doesn't belong to them. Already there is
Same
a
order.
judgment of the division bench. I filed the judgment of the division bench.
My lord, in
No, you are not utilizing the land belonging to petitioners.
They are only constructing the compound wall to protect.
Not on the land of the petitioners.
Not the land of the petitioner.
Mister, have you gone through it, Mr. Mishra?
My lord,
Says not the compound wall is not on your land.
my lord, I was waiting for the report to be filed because, my lord, my grievance is that the land doesn't fall under FTL. The same land was allotted by the counter. Once the copy of the report is given to me, I will submit my.
Kindly see 11, judgment of this all court at page 11.
You go through the counter filed by the whatever.
I'll file my
Who you
rejoinder.
know, who represent?
I'll file my rejoinder too. my
You
lord.
represent whom?
TSHC, my lord.
Ah.
That is
You file counter or reply whatever
I'll file my
rejoinder.
rejoinder to the same, my lord.
second respondent.
So grievance is so and so. Learned counsel for GHMC says that submits that the counter has already been filed on behalf of respondent number 2. Let reply if any to the rejoinder counter. Let us put it down. The agreement of sale.
My lord, I
CCC 5 and 7.
Last time, Lordship's directed us to file some synopsis in this.
Ah.
Because there are 2 LPAs and 1 repetition. I just prepared synopsis.
Yes, yes.
As simple as possible.
My lord, I am appealing for the appearance along with my junior T. Balajayasri in these appeals, and the repetition. My lord, my submission to your lordship that this litigation is started in the year 1983, and now we are in the year 2023.
Yes.
But for more than 4 decades, this litigation is dragged on.
It's now coming to an end so far as we are concerned. It will come to an end, mister. It's we are hearing. Please go ahead. Dragging.
Lordship will
Not dragging.
get a final disposal to this.
Definitely.
I hope.
Please.
Lordship will
No reason. We will not disappoint you.
Yes.
We will not disappoint you. Our job is to decide cases that we do to the best of our capacity. Go ahead, mister. This all.
In the year 1983.
This all. not relevant. What are the facts?
Now, the
They have
fact
given me
of
this thing.
the
Shall we hear the person that you are from the appellant?
I for the respondent, but I prepared it,
Lord, I am the
Then you are not saying anything about facts and saying all this 40 years, 50 years.
Lord, this is a litigation between two close relations. One is Mr. TDS Sharma and the other is TDS Satyanarayana. They hail from the same village in East Godavari district, and they are in the evidence it has come that they are close relations. Now, this litigation started in the year 1983 in view of the sale agreement. In view of the sale agreement, set to have been executed
1974.
by my client.
7th April 1974.
7473. 7474.
7th April 1974 is your agreement of sale.
By virtue of the agreement dated 7/4/1974. Lord, how this has come about is I have given what you call the chronology. I have given the chronology to your lordships. Lord, this I may submit that this matter was heard by your lordship's previous bench.
We can't do anything about it, Mr. It was heard, so I can't.
No, I filed all the papers before the previous bench.
Don't, Mr. Focus on merits of the matter.
Therefore, I am submitting that the papers are already submitted.
Please,
and now, the chronology which I have prepared, Lord, gives up the facts of the case. The chronology is already submitted to the previous bench.
Yes, yes.
No. Please correct me if I am wrong. Please, I will tell you the chronology of events. The appellant was allotted L2 type house in Vijayanagar Colony Housing Board, constructed by the Housing Board, under a hire purchase agreement dated 17/12/1968. Okay.
1967.
1968 is the hire purchase agreement entered in.
The allotment of the house was given to my client in year 1968.
That is why it said 17th
Housing Board has
17th December 1968. 4,000 odd rupees was paid.
68 అని చెప్పాను.
Yes. Lord, your lordship
could not pay the balance amount subsequently.
I have submitted
when you are required to pay. Then you have borrowed the respondent to pay the balance amount. Then R3 filed a suit OS 380 of 1983 for specific performance. Then you appellant also filed OS 594 of 1983 for recovery of possession. Then the suit was dismissed for specific performance was dismissed. Then CCCA 5 was filed. Then against
That was filed by the
another CCCA was
By the
filed
state
where the findings of the trial court have been reversed.
yes,
Now the appeal LPA arises out of that order.
and
Correct?
yes,
Now please proceed from there.
Please, madam, please tell him that judges have understood the facts. He can start submissions, right?
ఫ్యాక్ట్స్ వాళ్ళకి అర్థమైపోయాట సబ్మిషన్స్ చేయమంటున్నారు.
Yes, yes.
We have already told, right? Brother has already told what are the facts to you.
Is a short chronology. I would like to read this chronology, which will give out the full facts of the case. Kindly bear with me. This chronology is only about 1 or 2 pages. Your lordship got it. Would you get that chronology?
They have not
She's
got
looking for.
not got it. Knowledge.
This
Tell him that she's searching for.
This allotment of the fruit house. The allotment of the fruit house was made in the year on 27/9/1967 by the Housing Board in favor of my client, Mr. Satyanarayana. And 1968, Lord, after the letter of acceptance given by my client in 67, there was a lease cum agreement executed on 17/2/1968. Lord, by the lease cum agreement, that is Exhibit D1. Lord,
Exhibit B3.
Exhibit D3, lease cum agreement for sale of the house was executed on 17/2/68 by my client, Mr. Satyanarayana, in favor of the Housing Board. So then, in Housing Board gave memo to pay the balance amount because every year they have to pay the installments to the Housing Board. Therefore, in the 1970, my client was not, Mr. Satyanarayana was not able to pay the installment in the year 1970. Therefore, he approached the client, Mr. Sharma, the respondent, the defendant, in this, who was the plaintiff in the case, in the suit, for he borrowed 6,000 rupees from the Mr. P.D.S. Sharma in the year 1970, and he paid the installments to the Housing Board. Then, because the Housing Board has cancelled his allotment because he has not paid the installment in the year 1970. Therefore, he borrowed this amount of 6,000 and then he paid the installments, and the cancellation was cancelled, and again the house continued to be in the name of my client, Mr. Satyanarayana. And then what happened is, in 1973, when he borrowed this amount, there was it was a borrow agreement saying that the house was actually transferred in the name of by way of lease. The house was transferred by way of lease to this Dharma in the year 1973 itself. After I borrowed 6,000, on the condition that he was persuaded to hand over possession of the house by way of lease. Then, my lord, in 1973, the suit house was transferred in the name of the what you call P.D.S. Sharma, and in 73, again in 74, he could not pay the further installments. Then he again borrowed some amounts, and then what happened in 74? He was persuaded to hand over the possession of the house itself by way of this agreement, suit agreement, what you call this, it was executed on
74.
1974.
Exhibit
That was-
A1. Exhibit A1.
That was the agreement executed by, that has been executed by my client, Satyanarayana, in the favor of Mr. Sharma, in the year on 77/4/1974, under Exhibit A1. But the possession of the house was already handed over by way of lease in the year 1973 itself, whereas the agreement of sale was
Executed.
executed in the year 1974, 74, where I will read that agreement of sale. My lord, according to me, I was forced to the pleading which in my pleading was that because I borrowed certain amounts, from Mr. Sarma. Therefore, when I could not pay the installments to the housing board, according to this agreement of sale, the actual it was undertaken by the Mr. Sarma that he would pay the installments to the housing board. This is the agreement. I will read the agreement because this is the suit agreement under which the suit was filed by Mr. Sarma in the year 1983. That sale agreement gives out the full facts. Kindly see this exhibit A1. Exhibit A1 is the sale agreement.
Page 94.
Page 90,
94.
94 of the paper book, material papers.
What is?
Huh?
Check.
Kindly read at page 94. The exhibit A1, the agreement will give out the full facts of the case. This deed of agreement dated 7/4/1974, entered into by Madhupuri Surya Venkata Satyanarayana, that is my client, in favor of the so Mr. Godavari residing also
House bearing Mallepalli.
so in Hyderabad of the first part, and Madhupuri Venkata Subramaniam Sema also in Godavari district. Presently residing in 260 Mallepalli, that is the suit house. He was already residing in the suit house. By the time this agreement of sale was executed, he was already in possession of the suit house because the possession was given by way of lease in the year 1973 itself. When he borrowed the amounts about 6,000 and odd. At that time itself, the position was handed over to by way of lease to this Sarma. But 74, the agreement came into being. The sale agreement came into being on 7th April 1974. That the first party is the LOB of it gives the full fact. Now, may I read this agreement, paragraph 2. The first party is the LOB of the house, 260 by so Mallepalli, Hyderabad, which is allotted to him by the AP Housing Board by so letter dated 27/9/67. The position of which was taken on 17/2/68 by the first party. The said allotment was made by Housing Board.
Madam, please ask him to read the page 33, bottom last paragraph and page 30.
Of this suit agreement, my lord.
Exhibit same document,
33.
page 33,
Page-
that is the second one, second page of the agreement of sale.
The second page of the agreement of sale.
Agreement of sale, second page,
Second.
bottom last paragraph onwards.
Last.
Yes.
Last paragraph.
Lord, here
That besides the amounts, that one, that besides the amount.
No, that as the first party is not financially.
The first party.
Ah.
Ikkadi nunchi chadavamani.
the first party hereby agreed to sell the said house to the second party immediately after the second party remitted the amounts payable to the AP Housing Board on behalf of the first party and AP Housing Board transferring the title of the said house in favor of the first party. Then besides the amounts specified in earlier paragraph, a sum of 12,000 was agreed to be paid by the second party towards the balance of consideration to the first party to enable the first party to maintain its family. Details and role of daily as mentioned here that an amount of 2,000 and out of 12,000 was paid by the second party, the first party on 7,573. That is that an amount of 2,000 was paid on 21/7/3 to the first party by the second party. And the first party in turn put the second party in vacant possession of the said house along with relevant papers. The possession itself was handed over to him in the year 1973, even before the execution of this agreement of sale. Now, because he paid 6,000, he borrowed 6,000 only on the condition that the possession of the house was to be handed over to him, because he was penniless, he was not having money to pay the installments. Therefore, he was compelled to hand over possession by way of lease. Actually, it was possession was handed over to Mr. Sharma. Now, very necessary that the amount of 4,000 is paid by the second party. Therefore, here it is clearly stated that on 21/6/73, the last paragraph of this 96 makes it clear that the second position was handed over on 21/6/1973 itself, whereas this agreement came into being in 74, on 74/74. Now, that the amount of 4,000 is paid by the second party, the first party, on 74/74. That the balance of 4,000 is to pay to the first party in full and final settlement. To the state, they have the insurance. The first party here is not any of the agreement to anybody. The first property condition. This agreement of sale, according to me, according to now, this agreement of sale was, according to Mr. Satyanarayana, it was not executed. It was what we call it was on some plain blank papers. The statement of my client was this agreement is not executed, but it was on blank papers that my signature was taken. That was it was forcibly my signature was taken. That was the
signature is not forged, forcefully taken. Signature is not forged, it is forcefully taken. There is a difference between forged and forcefully taken.
What my previous submission is with, it has been forcefully.
That is what we understood, not forged.
Forcefully.
Now, because my client was not able to pay the installments because he is penniless. He was not able to pay the installments to the housing board. Therefore, this agreement of sale came to me by force, by
Coercion. Coercion, you can say, coercion.
by using pressure on my client, and now because my client has not agreed for this agreement of sale, then even after payment of installments, because it was a concocted agreement, because he did not agree for this agreement of sale, then Mr. Sharma filed the suit for special performance
OS 380.
on OS 380 for special performance of this agreement of sale.
And my client has filed 590.
And my client, Satyanarayana, filed a suit for recovery of possession and mean profits. That is the other suit filed by Mr. Satyanarayana. Lord, both the suits were heard together.
And common judgment.
The first suit was by Sharma for special performance, and the second suit filed by my client Satyanarayana was for recovery of possession, because possession was given in the year 73 itself, long before the execution of the agreement of sale. Because according to me, it was only by lease that this possession was given. Now, the points that arise for consideration is this agreement of sale is contrary to the provisions of the Housing Board Act. Housing Board Act and this agreement, lease agreement, do not confer any right on this Satyanarayana to either to lease or to alienate the property during the pendency of this hire purchase. He is only a tenant. He cannot execute any sale or lease or in any other manner. He can't part with the possession of the property. That is one of the conditions of the agreement, exhibit D1. That I will come to it, my lord. This agreement, lease sale agreement between the Housing Board and my client does not permit either to lease the property or to alienate the property during the pendency of this agreement of lease until all the installments are paid and the property is transferred in the name of my client. Till such time, my client remains only to be a tenant, and he has no power to alienate the property either by way of lease or in any other manner. He can't part with the possession property. These are the terms of Exhibit P1, lease cum sale agreement, which I will point out on the next hearing date. Now that the time is over, I don't want to.
No, please continue.
Some more time, please complete.
Continue.
Now I will come to it. I will come to Exhibit D1.
Yes.
Lord, Exhibit D1 is the agreement, lease cum sale agreement between the parties, between the Housing Board and my client, which prohibit any ease of passing with the position by any This lordship will get it at page number 3. At page 131 of the chapter 2. It will be given. Yes, your lordship.
Yes.
Then,
Your lordship.
it will be given, not in the allotment order. It will be given in the allotment order, which also prohibits that gives out the terms how this high-pay sales agreement came into be. When we see the order issued by the Housing Board at page 131 of the paper book, when we see that it is given in the order by which the House allotted to Mr. Satyanarayana. House, now the lordship got it.
Yes.
Page 131.
Yes.
House page 19, whenever allotted to Satyanarayana, they are pleading. The allotment is provisional, subject to the following conditions. The applicant will send within the acceptance of the allotment in so called not within the appendix. The allotment to be cancelled without authorization to be elected not received within the term specified. Immediately, an applicant to the release of the fund and the administration allotment is done. The result of not administrating the subject of the check. The allotment is finished. Percent of the original cost. Then
ఇక్కడ ఇంపార్టెంట్
Then,
it should be
I'll read the other. Item.
Eighth para.
Eighth paragraph. It should clearly be understood that the house should be used only for the residents of the allotment of this family, and it should not be let out without the prior permission of the chairman. That is the mandatory condition.
The next
Mentioned in the allotment letter. And for them, allotment can provide both terms and conditions of the lease agreement and regulations.
So
Therefore,
next
the allotment is bound by the conditions stipulated in the order. The order, and also in the terms and conditions of the
lease come agreement is here.
Agreement.
Lease
Now,
come.
you also will find the agreement.
Lease comes here.
These comes there agreement. It is between the parties.
In the and the housing.
Between the housing board. And then it will be mutual consent letter.
Lease come sale agreement.
These comes there agreement. Executed between the housing board and
the
on 17th February. Between the housing board and Mr. Satyanarayana.
Next, coming to the next, whereas the list.
That's right. To be let out for allotment of the tenant and the premises constructed with the
Low income group.
Income group.
Sponsored by government.
Sponsored by the government of India. Regulations. The trade under the Safety Housing Board. And this when the Minister has agreed to keep the tenant and premises in all the fields and parcel of land, particularly described in the schedule, and which together with the will not referred to as the property to the lessee on the terms and conditions hereinafter mentioned. Now, this
First,
indenture, the conditions are mentioned here. Until the time as the lessor conveys the property to the lessee, hereinafter stipulated until so and so, the lessor shall occupy the property as lessee on terms and conditions as mentioned, and the lease shall commence as then from the date of the indenture until the rent for the property is finally fixed by the chairman of the lessor. Under clause 3, the lessee shall pay to the lessor the provisional rent of 1631, whereas the rent to be paid in advance on 10th of commencing on 10th. If they especially agreed with the part, so
important.
a design. And so discussion, the rent to be fixed under this clause and between the provisional, that is as per the fixation of rent. Then will all the one of the important terms which I will read is the para 7 of the agreement. The lessor agrees to sell subject to the provisions in the regulations the property to the lessee after expiry of 5 years from the date of this indenture of payment of sale price as the chairman of the lessor may at any time in after so fixed until such time the chairman of the lessor finally determines the sale price of the property. The extra next to lessor a sum of 16 as original installment towards some system. Installment ultimately the lessor of the sale price has been finally determined by the lessor should be become then the Lord. Some of the important clauses in this agreement which prohibit any alienation.
Para 11.
Kindly see, my lord, is
Para 11.
yes, after fixation thereafter. Para 8 also is important. My lord.
Para 8 already read.
Madam, your case, as I understand, is that the ground which you have taken is because of the total prohibition of alienation, the so-called agreement of sale, first of all, the lease by which Mr. Sharma is put in possession, and the subsequent agreement of sale of 1974 are void.
Yes.
Therefore, the end it is also contrary to the housing board, the lease come sale agreement which you have entered into with the housing board is contrary to that. Therefore, you are he cannot claim any right under that. I understood. Next question of law.
Question of law. Two of the important clauses in this agreement which prohibit any.
I have read the agreement, sir. I have read the entire agreement. Don't worry.
Para 11, kindly see para 11, para 12, and then lost me kindly see.
No, question of law you have raised. Please tell us on the legal aspect. Rest of the facts we can read.
Yes, ma'am. ఇది లీగల్ ఆస్పెక్ట్స్ చెప్పమంటున్నారు వాళ్ళ ఫ్యాక్ట్స్ దే విల్ రీడ్
The para 22 of this agreement is very important. Kindly see para 22 of this. The lessee shall not assign
Sublet. I have read it, madam.
He has read it.
Not that I have not read it.
He has read it. He understood.
Please address us the legal aspect.
Saying that it is contrary. This is contrary. They have understood. Only now submissions of.
Para 26 kind of thing.
They have understood.
This is very important. Well, para 26 again is very important. The para 25 and 26. Lessee shall abide
by the regulations 26 is contravention of the terms. I am telling you, I have read, please understand.
Daddy.
Please tell her, address us on the legal aspect.
Legal aspects, he has understood.
Which
They have
provision
understood.
of law, which according
They have
to
understood.
specific.
Therefore, no, I only point out that clause 25 and 26 are also important.
Yes, yes.
I won't read, but kindly make a note. Clauses 25 and 26 and clause 22 are totally prohibit any alienation by way of transfer.
They understood that.
Of,
That aspect has been understood. Appreciated.
Now, I will read, according to me, some of the provisions of the Housing Board Act. Lord, while coming, before I come to the judgments of the trial court and the trial court, after an exhaustive
Appreciation. Exhaustive appreciation.
exhaustive
Appreciation.
Discussion and found that this agreement of sale is contrary to the housing board provisions of the Housing Board Act and the regulations of the Housing Board made by the housing under the regulations. That I will come to it. Now, the important provisions under the Housing Board Act, I will just only read the relevant provisions of the Housing Board Act and the specific relief act. Before I go to the judgment, I will read the important provisions. Now, section 17.
Specific relief act today. Yeah, Housing Board section 21. Here.
Section 21, 22, 45. Now, these are the relevant sections of the Housing Board Act, which I would like to read to appreciate my intention, because the trial court held it is contrary to the provisions of the Housing Board Act. The agreement is contrary to the provisions of the Housing Board Act. Therefore, this agreement cannot be enforced by way of specific performance.
See,
come to that conclusion.
1 second, I'll tell you, the Housing Board Act says, till the final payment is made and a conveyance is executed in favor of the allottee, he cannot transfer the property. If any such transfer is made, the same shall not be binding. Those provisions will read. Please elaborate on the clause section. That's all.
Important for my submission, because the trial court has held that the agreement is contrary to the provisions of the Housing Board Act. I will only read the relevant provisions of the Housing Board Act, which say it is contrary. Only certain sections, not all the sections. Sections 21, 22, 45. The Housing Board Act. Kindly give Housing Board Act.
We are getting it. In the meanwhile, you can go ahead.
Yes, please go ahead. I have a paper.
అన్ని చదవమంటున్నారు.
I'll read now. The matters to be provided.
And section చెప్పు 22 అని చెప్తే సరే.
Yes.
Section 22 అని చెప్తే.
Section 22 of the Housing Board Act. Get the Housing Board Act 1956. The matters to be provided by Housing Scheme. Notwithstanding anything contained in law or standing, Housing Scheme may provide for all the following matters. Laying or going out of any land compared with the scheme. When the acquisition by purchase extent of the property necessary affected by the execution of scheme, then
45 and
section
45.
22.
22 లో జీనా
Section 22 means the matters to be provided by that. Then section
45.
Section 45 is important. Section 45 deals with
45 power to dispose.
Subject to any rules made by the government. The board may retain, exchange.
Sell exchange.
Dispose of any land, building, vesting in and situated in the area comprising any housing street mentioned under this act. Then there are
52.
section 52.
52 power to evict.
Power to evict the person from those premises. This is important. The competent authority is satisfied that the person authorized to occupy any both premises has, whether before or after the commencement of the act, not paid any rent lawfully due from him in respect of the premises for a period of more than 3 years. The sublet without the permission of the board, the whole or any part of such premises are otherwise acted in contravention of the terms express or implied under which he is authorized to occupy the premises, that any person is in unauthorized occupation of the board premises to competent authority notwithstanding any local time given by notice of the post. So, or other one maybe person and the clinical requisites. So, therefore, if any contravention of the provisions of this act, he is liable to be evicted under section 52. This is one of the decisive provisions of the section 52.
Judgment lo
And then after 55, 68, 70, 71, section 68. Section 68.
Notice
of suit against board. No person shall can commence any suit unless against service on suit, acting under the orders of the board. The perspective going persons without giving to the board as also notice in writing of the intended suit after 6 months from the date of the act, just like section 80 of the CPC. Yes, notice has to be given.
It is 70.
Then not section 71
regulations
is the provision which provides for the regulations to be made by the housing board. And we see this gives the power to the board. The board may sometimes, very important, that's why I'm thinking this. The board may from time to time, with the previous sanction of the government, make regulations consistent with the act and with any rules made. So, for the management of meetings, the principles and procedures to be followed for regulating the board procedure and the disposal of the board. Power to make bylaws.
అది ఇంకా అక్కర్లే 79 నెక్స్ట్ 79 రాసాం ఇక్కడ
79 is government's power for supervision.
Government
My
power.
lord, we have also submitted judgment cited in LPS.
Yes, I have it.
Your lordship has got it.
Yes.
Then I read the relevant provisions of specific relief act, only relevant provisions, which prohibit alienation.
17, section 17.
Section 17 is very decisive. This section 17 says of specific relief act, your lordship kindly get the that
Section
17.
17.
17.
Section 17 of the specific relief act. Contracts to sell or let property by one who has no title not fiscally enforceable. Very important section. A contract to sell or let any immovable property cannot be specifically enforced in favor of a vendor or lessor who, knowing himself not to have any title to the property, has contracted to sell or let the property. Who, though He entered into the contract believing that he had a good title, cannot pay the time of the party for the completion of the sale, or let him give the purchaser or let him a title free from reasonable doubt. Lord, this section 17 is a complete embargo on the for the alienation of the property by by my client, who is only a lessee, who is not having any title as per the provisions of the what you call the
Specific.
Exhibit B3 and Exhibit B1.
Then
Now,
20.
next section, which is
20. 20, section 20.
20.
This stands. Section 20. Discretion as to decree.
Now, section 20 is another important provision. Discretion to decreeing of special performance.
Yes.
The jurisdiction to decree special performance is discretionary. And the court is not bound to grant such ruling merely because it is lawful to do so. But the discretion of the court is not arbitrary but sound and reasonable, guided by
judicial
principles, capable of correction by court of appeal. The following are cases which the court may properly exercise discretion not to decrease special performance, where the terms of the contract or the conduct of the parties at the time of entering into the contract or other such circumstances
under which
the contract is entered into, or such that the contract do not vulnerable, is the unfair advantage over the defendant. There is performance in contract will involve some hardship to the defendant on the defendant which he did not foresee, whereas his non-performance would involve no such hardship on the plaintiff. Where the defendant entered into the contract under the expression which is not rendering the contract void, makes it inequitable to ensure special performance. So, please, one. Mere which is very individual, or mere third contract, or which shall not be deemed to constitute unfair against you. Even the meaning of clause of hardship in the meaning of no. The question whether performance would involve hardship on the dependent of the job. So, activity cases where you are very good. And we have to think, but this is the definition of the contract. Now, below section 24 is again decided because that prohibits any that's not conception. Now, section 24, if your lordship kindly sees, all of suits for compensation for fees after dismissal of suits for specific performance. Now, this section 24 says, dismissal of the suit for specific performance of the contract or part thereof shall bar the plaintiff's right to seek for compensation for the breach of such contract or part of it, but shall not bar the right to sue for any other.
Make it 23. This temperature is 20.
By reason of breach.
23. Sorry. 24.
Madam,
Yes.
we have understood. You have given written synopsis, point of law. Anything further you want to add to that? We have your written synopsis and point of law with the case law being relied. If anything beyond this, please tell us. Otherwise, we'll go through this.
వాళ్ళ దగ్గర జడ్జ్మెంట్స్ మనం ఇచ్చిన సినాప్సిస్ అంతా
Synopsis with case law. We will go through that.
అదంతా ఉంది. బియాండ్ దట్ ఇంకేదైనా ఉందా చెప్పేది మేము అదంతా చదువుకుంటాము అని అంటున్నారు.
These judgments I want to cite.
No, anything other than what is not cited in this synopsis, please tell us.
దీంట్లో లేనిది ఇంకేదైనా
ఇందులో
ఈ జడ్జిమెంట్
మీరు ఒక 6 పేజీలు ఇచ్చారు మాకు.
కదా
6 page note you have given.
పేజెస్ నోట్ ఇవన్నీ ఇచ్చాం కదా అట్లా.
Lord, I would like to read some portions of the trial court judgment and the appellate court judgment to point out.
1 second, don't strain your vocal cords. Please tell us which part. We will note it down. We will read ourselves.
See, the trial court has dismissed the suit for performance, holding that it is contrary to the provisions of the Housing Board Act and the regulations made under the by the Housing
That
Board.
is what I said in the beginning itself. What we have understood by reading your pleading, we understood that the OS 350 was dismissed because being contrary to law. Then CCCA was filed. CCCA was allowed, against which you have come in LPA.
There are some important point I would like to enlighten in the grounds of appeal. Lord, what was stated? Lord, in the grounds of appeal filed by the what you call the respondent, Mr. Sharma, he has only claimed compensation. He has not assigned the degree for specific performance. That is very crucial.
40,000 what was awarded.
Now, this is the very great importance because I am citing one very important Supreme Court judgment.
Please.
To support my contention that because kindly see in the appeal grounds filed by what you call the Sharma before the first appellate court, he only claimed 55,000 as compensation. Kindly see this last paragraph of the grounds of appeal in what you call in CCA 7 and CCA 5. They are very important for my submission because he did not assail the decree for specific the dismissal of the suit. Specific performance was not assailed. In the appeal, he only claimed compensation of 55,000 and 44,000 towards the amount paid by him towards installments to the Housing Board and 18,000 to the Sajjanarayana. That comes to 44,000. That amount of 44,000, the trial court said, you pay that amount and then possession will be recovered. Order for recovery of possession was granted on payment of 44,000. That they have not assailed. As for they are prepared to pay 44,000. And also, now this in the grounds of appeal, this assumes a very great importance in your Supreme Court judgment, which I want to emphasize, which is the latest judgment of the Supreme Court, 2022. Yeah, he only allowed, kindly see this paragraph 20 of the appeal court.
No, please, sir. 2022, 2 SCC 221.
Yes.
We have it, please.
Lower court also granted a decree for a sum of 1 lakh, lakhs including damages, each of agreement on the part of prosecution. The other are not sound.
Also the court.
Value of the appeal restricted to the amount of 1 lakh. That is, lower court decreed 44,000 and the total of the appeal is 55,000. He is paying.
Also court fee is also paid for that.
Kindly, this is of very crucial importance for my legal submission based upon the latest Supreme Court judgment, which I should cite on the next occasion.
No, please.
Now 5 o'clock.
Please complete. Don't strain yourself. Please complete. We are sitting here for some more time. Don't worry.
Citation I am giving.
Already they have.
No, 2022, I will give you the citation, 2022 2 SEC 221. 2022 2 SEC 221. This is what you are going to rely.
అదేమో కోర్ట్ ఫీజు కూడా అంతే పే చేశారు.
Court fee is paid only for that purpose. Well, the same thing with regard to the other grounds of appeal.
Yes.
In appeal 5 also, the same, he claimed only 44,000 and 55,000. Same thing. And he did not claim anything else.
Yes.
And here, one more important fact to be seen is, see, here, the question of the relationship is also pointed out. Kindly see this paragraph 19 in the appeal ground mentioned. Paragraph 19 of the appeal grounds.
Yes.
Which kindly see, in view of the findings of the lower court not held, first defendant cannot enjoy the benefit of improvements made at high cost by the plaintiff without applying the same as a matter of equity and good conscience, especially in view of the findings that the plaintiff was induced by the first defendant as a close relative to come to his rescue and help him out with advance of funds extending over a number of years. Here, there is a clear commitment that he is a close relative. Relatives, that's why, my lord, in the appeal, he did not claim, he did not assign this degree of specific dismissal of this specific performance that he has not assigned. He only claimed because he is a close relation, he has restricted his claim only for the 55,000.
Fine, understood.
Now, which, Lord, I gave him a memo of compromise also.
Yes.
We are prepared to pay that 55,000 and 44,000. We are prepared to pay, given the memo of settlement.
Yes.
Which is given to
2,000, around 2,000 you tried to enter into some compromise. That did not go through. I am aware. Yes.
That was not agreed to.
Yes, yes.
Because this 44,000 decreed by trial court and only on payment of that position will be recovered.
Yes.
By my client. That we are agreeable. 44,000. And 55,000 also, by way of settlement, they are prepared to pay that amount also. If, because there is no deal. But the point which I would like to emphasize is, he has abandoned the relief of relief by way of
Assailing his suit dismissed filed for specific performance. But I have noted. He did not. He did not assail the dismissal of suit for specific performance. That we have
that was not assailed in the appeal.
Yes, yes.
And similarly, in the other appeal, he has not assigned the degree of
money
function. That also is not assigned.
Yes.
He only raised the restricted amount of 55,000.
Fine.
Now, the latest judgment of the Supreme Court, which I would 22. This judgment, I totally rely upon this 22 two Supreme Court cases, 221,
Paragraphs you want to tell us, we will tell you. One second.
Abandonment of statutory.
Paragraph 17 to 26. We have read it. Yes, don't worry. Paragraph 17 to 26. ఆయనను కూడా చెప్పనియండి, మీరే చెప్తానంటే ఎట్లయితుంది?
ఇప్పుడు ఆయన కూడా అదర్ సైడ్ కూడా చెప్తారు, మీరు కూర్చోండి. నేను చూస్తాము అని అంటున్నాను. ఇవి చూస్తామంటున్నాను. ఇవి జడ్జిమెంట్ ఇది చూసామంటున్నాను. Relevant
paragraphs. This paragraph is very
I have read it, sir. From 17 to 26, I have read it.
He has granted that right.
Mister, this is only a authority for the proposition that statutory right can be waived by a party. no difficulty in accepting this, right? Go ahead,
Statutory right here.
can be waived.
Can be waived and unclean.
That's what has been.
That was waived. My lord, that was the judgment in 2022.
Go ahead, then we have understood this, that
Lord,
statutory right can be waived.
This is a very important judgment I wanted to rely upon because he has abandoned very good letter, right? And therefore, by way of estoppel, by way of promissory estoppel also, my lord, by way of promissory estoppel, he is estopped from claiming any specific performance, things like that.
So, and also one more thing. Really, and also one more point, that relief not sought for cannot be granted.
15 years ago,
The relief petition.
so.
This is the judgment of the appeal court. I want to point out that even though he has not claimed this, assailing this, the first appellate court has decreed specific performance, which is absurd. Because he has not claimed any relief with regard to specific performance. And
For that judgment, 2006-5 is
that use.
what you just say.
Lord,
For that judgment.
appeal court judgment here. Lord,
అది వాళ్ళు
appeal court judgment here. Well, I would like to point out certain portions of the appeal court judgment. Appeal court judgment kindly, even though he has not
heard you almost for an hour, mister. 1 hour, we have heard you.
1 hour విన్నాము. Side.
Yes, go ahead.
No, but this point is of very important submission. That is, where he has not assailed the dismissal of special performance, the lawyer argues again that that particular paragraph I wanted to say. He said, but
జస్ట్ ఓరల్ గా చెప్పు.
no, take out that paragraph.
10 minutes.
బుక్ లో రాసా.
By the bench.
అదే ఇంకేదో జడ్జిమెంట్ 2008 డైరెక్ట్ 2008 ఏదో చెప్తాను. ఏది ఎక్కడ
the lawyer in the first appeal, he has again argued the point of that is about what you call this agreement is quite valid. Specific performance has to be granted. That is what the lawyer has submitted before the. Kindly see at page 67. Page 67 of the appeal court judgment, which your lordship kindly see.
Here.
It is the submission of promissory authority, the senior counsel appearing for the plaintiff, that the suit agreement is not forbidden either by 23 of the Indian Contract Act or the terms of allotment of the suit house in favor of the first defendant, or the terms of the conditions of the these agreement of sale entered into between. Well, how can he raise this plea? How can
Why
he
you
argue?
did not oppose him? Why you did not tell the court that he can't raise the plea? All right, we'll continue tomorrow.
అప్పుడు కోర్టులో చెప్పవలసింది అంటున్నారు.
Mr. So and so learned counsel for the applicants comments his submissions. However, On account of paucity of time, same could not be concluded. List for further hearing on 16/8.
Item 47, 48, I'm sorry, God.
What to do?
47, 48 was passed over for a hearing. Full final hearing, but the.
Could be taken.
We lost, haven't got the.
We gave him 1 hour. Despite that, he did not conclude. What can we do? 1 hour, 10 minutes.
Quite seeing the Lord.
Yes.
But.
We are hearing him with all the patience at our command, but
I quite see. 70.
we cannot, because if we communicate, there will be again this thing. So yes, Mr. Advocate General.
My lords, I subject your lordship's pleasure any day, my lord.
No, not pleasure, but what to.
Lord, I want to cite some very important judgments on promissory estoppel of Justice Bhagavati and 2008 to Supreme Court.
No, it will.
Regarding promissory.
Madam, tell him that it will be heard on 17/8 now. Whatever, not 17, 16/8.
I will cite only some very important judgments.
Ask him to, madam, please request on our behalf. We have given him 1 hour and 10 minutes. Ask him to conclude. It should not take this much of time. No. That's why we understand that he has to be given benefit of his age. That's why we are very polite and we are not saying anything exercising. So please tell him to be reasonable, like 1 hour, 10 minutes. I mean, like this is not the only case before us, right? Others are also waiting. His senior counsel's case was passed over. We sat till 5:10 in the fond hope that he will conclude today, but no chances. What can be done? We have sat extra 40 minutes. Ask him to be reasonable, right? You understood.
Written submission also.
It is already there.
It is there. We have already had the submission.
1 hour, 10 minutes. If you can't conclude, then this thing, these are not the good old times where we used to hear second appeals for 2 days. You must realize the burden. This High Court has 250,000 cases pending, more than 250,000.
We will make a few written submissions.
Already there. You want to give whatever you want to. Nobody prevents, right? No. But then after giving written submission, don't argue then. We will not permit argument for another hour. Tell him. Mr. Advocate, you are looking at the chart which we have prepared to find out which day you can be accommodated so that you are not required to wait. Yes.
28th, my lord, subject to your lordship's consent.
28th. Wednesday.
20, if not earlier, difficult. 1 day after or 1 day after of 28th is also fine. That's Tuesday, Wednesday.
29/8. Will that do?
Yes. Those 3 days continues to have. So then first week of September.
First.
3rd of September.
No, it's Friday. Monday. No, again Tuesday. 5th September.
4th September, yes.
5th.
5th, fine, my lord.
Again, Monday is 4th, and there will be, we don't know.
My lord, 5th is fine.
5th September. On account of paucity of time, matter could not be taken up. His case, 48 and 49, Learned Advocate General appears. This 5th September 2020. It will continue.
Outstation, you are
So at 5 o'clock, you are telling I am outstation. You tell us. So his case is listed on 16/8. Don't come on that day unless you have an assurance from him that he will conclude within 5 minutes. Lighter vein, Mr. We can't prevent him from. Yes. What date?
There is also restriction also is there.
Yes.
There is a restriction also.
Why he should speak? His case is coming up on 16th August.
Can be on 11th of September.
That will again a Monday. All right. Why don't you 12th September? 12th.
12th September.
11th, 14th and all that.
But
12th I have difficulty in the home because I am the home.
What?
14th or 15th.
11th.
11th Monday.
11, 14, 15, whichever dates.
14 is also.
14th September. on account of paucity of time, not taken. Please mention the matter, Mr. If you keep on waiting, we can't do anything about it.
Item number
Your
80.
outstation comes with
Your item number is 80. 80.
80.
This is relating to asset reconstruction company taking over.
14 September. 14 September.
79. No.
Rest everything repeat, madam. Everything repeat. Is further hearing it will come on day after, right? 16th August.